inherently human rights claims. So in particular, claims for family reunion or private life established in the United Kingdom. And then on the other hand, you get applications for leave to enter as a student or leave to remain as a skilled worker, those sorts of applications, which are not inherently human rights claims at all, but in some circumstances they might be. So that's the gray area. So I'll be looking in particular at the recent Court of Appeal case of NY, Pakistan, on appeal from a presidential panel of the upper tribunal. But first of all, I'd like to go back a bit and consider another upper tribunal case, a judicial review called Mujahid. And again, the tribunal was chaired by Mr. Justice Lane. Now, this was a case where a Tier 1 general migrant had clocked up his 5 years and was hoping to get indefinite leave on that basis. But he was a bit apprehensive about whether that would happen because there was a problem with the income which he'd disclosed to the Inland Revenue and the income which he had put forward when applying for indefinite leave under tier 1. So out of abundance of caution, he also applied for indefinite leave on long residence grounds, having actually clocked up 10 years residence in the UK. And because that was a later application, it superseded the first. But that also was refused because of this problem with Her Majesty's Revenue and Customs and the discrepancy between that income and the income that he declared to the Home Office. So that led to his being refused on the grounds of, conduct, character, and associations. It's never a matter of course that you'll get indefinite leave after 10 years lawful residence. You could still be refused because of your behavior or misdeeds during that period. However, Mr. Mujahid was granted leave to remain on the 10-year route as a parent because he had a daughter who'd been here for more than 7 years. Now, not content with that, he wanted to appeal against it. And initially, when he lodged his notice of appeal, a first-tier judge decided that he didn't have a right of appeal because he hadn't applied for a leave to remain on human rights grounds. Well, that was actually wrong because his initial application was not a human rights claim for indefinite leave as a Tier 1 general migrant, but his second application for indefinite leave on the long residence route was inherently a human rights claim as far as the Home Office is concerned. However, when the matter came before Upper Tribunal Judge Martin, she decided that although he had made a human rights claim, he couldn't actually appeal anyway because he'd been granted leave to remain for 2.5 years. He was not facing removal, and your human rights really are only triggered if in fact the decision means that you will have to leave the United Kingdom. And this wasn't the case here. Well, ultimately his appeal came before the Upper Tribunal, and they reached the same conclusion as Upper Tribunal Judge Martin when she was sitting in the first tier to decide the application for permission. And the Upper Tribunal also decided that because removal wasn't imminent, Mr. Mujahid didn't have a good human rights claim. Now, on the way to this conclusion, Mr. Justice Lane had a look at the well-known case of Balajagari, which was where Tier 1 general migrants had been refused indefinite leave because of this problem with HMRC. And Lord Justice Underhill decided that such an application could be treated as a human rights claim without having gone through the formal procedures of making a charged application on human rights grounds, where removal was imminent. So that is a very well-known decision by the Court of Appeal. But in Mujahid, Mr. Justice Lane insisted that otherwise than where removal is imminent, the formalities do have to be observed of making a charged application, as mandated by paragraph 34 of the immigration rules. Well, now we come back to MY Pakistan, which led to the Court of Appeal judgment that I'll be focusing on. So this again, initially, before reaching the Court of Appeal, was dealt with by Mr. Justice Lane in the presidential panel. And this concerned not a Tier 1 migrant, but a spouse who was here on, he hoped, the 5-year route to settlement. But he didn't reach that point. He instead made an application for indefinite leave as a victim of domestic violence. So that's the DVILR route under Appendix FM. He said that his wife and her relatives had been making his life a misery, and he was suffering from depression, and he couldn't go back to Pakistan because his in-laws there would do him in. Anyway, the application was rejected by the Home Office because his story was uncorroborated, and there was no right of appeal because, according to the Home Office, a domestic violence application is not a human rights claim. Now, apart from domestic violence, there's only one kind of application under Appendix FM which is not regarded as a human rights claim, and that's bereavement of when your partner passes away and you are a bereaved partner or spouse. Anyway, there was the possibility of applying for an administrative review. Mr. MY did that, but he also purported to give notice of appeal, and he was in luck because either a duty judge or a tribunal caseworker deemed the notice of appeal to be valid because human rights had been raised in the application. So the appeal went ahead and was heard by first-year Judge Kelly, but he agreed with the respondent that there could only be a right of appeal if the application was regarded as a human rights claim. The respondent, the Home Office, didn't accept that it was, so as far as the judge was concerned, there was no jurisdiction to entertain the appeal. However, he thought it would be a good idea if the matter went up to the upper tribunal to give guidance, because there was uncertainty among first-tier judges about this situation. And so that's why the appeal did come before a presidential panel of the upper tribunal. It's worth observing at this point that although an application, or rather a notice of appeal, can be turned down as invalid because there's no right of appeal, and that's not a matter which can go up to the upper tribunal, the remedy for that would be a judicial review. If in fact a jurisdiction point comes before a first-tier judge at a hearing, if it gets that far, and there's a question mark over whether the tribunal has jurisdiction at all, if the judge decides there's no jurisdiction, that can be appealed to the upper tribunal. On the other hand, if the Home Office says there was no jurisdiction, the judge shouldn't have entertained the appeal, that also can go up to the upper tribunal. So let's move on and see what the upper tribunal actually made of this appeal. And they took a look this time at a Court of Appeal case called Shrestha, in which Lord Justice Higginbotham said more or less the same as Lord Justice Underhill in Balajagari, namely that an application for something else can be treated as a human rights claim in the situation where removal is imminent. In that situation, the Secretary of State can waive the requirement for the proper procedures to be followed and a separate charged application to be made on human rights grounds. But he insisted, said his lordship, that the formal requirements do have to be met normally, which was more or less what was said in Balajagari. Now, at this point, Mr. Justice Lane looked at two sets of Home Office guidance for caseworkers. And the first one is entitled Rights of Appeal, and it keeps being reiterated, reissued in new versions. The most recent is version 11, published last December. And this tells caseworkers both which applications are regarded automatically as human rights claims, and also gives guidance on other sorts of application which might be human rights claims. And the other set of guidance is called Applications for Leave to Remain, Validation, Variation, and Withdrawal. And the most recent version of that was published last October. Now, this says something which is well known and not controversial, that you can make an application for leave to remain, and before the application is decided, you can lodge another application. Now, that will be treated as a variation of the first, and even though it might be for something completely different, it will still be treated as a variation of the first application, but it will supersede the first application. It will take its place. But what happens when the first application is decided? You've got a decision. Surely, according to Section 3C of the 1971 Act, you can't then make a second application to vary the first one. You're stuck with the application that has been decided. But, says the guidance, you can make a second application which will be considered by the Home Office if it is a human rights claim. Now, personally, I don't think that's right, because Section 3C(4) of the 1971 Act expressly forbids the making of a further application, which is not a variation of an as yet undecided application. So I'm not sure there is a statutory basis for saying that an application made in those circumstances has to be decided by the Home Office. And I would be interested in any comments or suggestions that you might have on that topic. Anyway, I'd better rattle on to the end of the upper tribunal consideration of MY. And this also involved considering whether it was right that only one single form can be used for one application, so that, as in Balajagari, if you make an application under Tier 1 for indefinite leave, that can't also be considered an application on human rights grounds. And Mr. Justice Lane concluded that the respondent can, as a general matter, lawfully respond to a human rights claim by declining to consider it. Okay, so in the case of MY, he made a human rights claim under the long residence rule, but because he'd already been granted 2.5 years on the 10-year route, it wasn't something which actually fell to be considered on appeal because he'd got leave to remain. He wasn't at risk of being removed any longer, not for the time being anyway. And so the Secretary of State could simply decline to consider his human rights claim. Okay, well, now we get to, at last, MY Pakistan at the Court of Appeal. And here, quite appropriately, the leading judgment was written by Lord Justice Underhill, who actually is the author of quite a few Court of Appeal judgments in the immigration sphere. There were 2 other grounds of appeal, but I think we can just leave them out for now, impugning the one application at a time policy and the forbidding of multiple applications. Those 2 grounds of appeal were rejected by the court, and he noted that he had said in Balajagari, oh, before I come to that, let me just mention that he returns to Mujahid and notes that the domestic violence rule does not constitute a human rights claim according to the Home Office. And what's the justification for that? Well, his lordship says that actually, unlike most other applications under Appendix FM, where a negative outcome leaves the failed appellant at risk of removal, that's not the case with domestic violence, because the question to be decided is not whether the appellant is an overstayer and should be removed, but whether the relationship with his British or settled partner broke down because of domestic abuse. And that's a different kettle of fish. So that's the justification for not treating domestic violence claims as human rights claims. But anyway, his lordship then takes a look at his own judgment in Balajagari, which included a suggestion that because there is a box in application forms inviting the applicant to raise other matters which would enable him to include a human rights claim as part of his application, that would be an entree for applicants to actually make a human rights claim at the same time as they're applying for something else. So his lordship now resiles from what he said in Balajagari. He was going too far. And in fact, he says that the passage in question where he makes this suggestion is plainly both obiter and not based on full submissions, so it cannot be relied on by appellants. And in fact, he praises Mr. Justice Lane in Mujahid for taking a skeptical approach, in fact, to what had been said on this matter in Balajagari. So I comment at the end of that bit of my update that backtracking on Balajagari will make it more difficult to argue that an application which is not inherently a human rights claim should be regarded as one. So going back a bit, restricting the scope to argue that an application that you've made, say for leave to remain as a skilled worker or as a student, should also be treated as a human rights claim. Well, now we come to a topic which keeps recurring. It exercises minds constantly in this jurisdiction. It's the scope of Section 3C of the 1971 Act. Now, it's probably well known by all of you that there are three situations in which Section 3C comes into its own. Now, first is when an application is made in time for further leave to remain. No matter how long it takes for the Home Office to decide that application, the applicant continues to have leave to remain, which is extended beyond the point when it would have come to an end by virtue of Section 3C. So you could be going on for months and months after your leave would normally have come to an end by virtue of Section 3C. Now, the second point where Section 3C kicks in is if the application is refused. You've then got 14 days to lodge an appeal, and during that period, you have Section 3C leave. So your leave doesn't expire during the period during which you could give notice of appeal. And then the third situation will be if you do have an appeal, if permission to appeal is granted, then your leave continues during the period when that appeal is pending. And it's pending until it's finally withdrawn or determined or abandoned. So if it's not abandoned or withdrawn, it could go on for months and even years, going to the first tier tribunal, the upper tribunal, etc., maybe up and down. So those are the three well-known situations when your leave is extended by Section 3C. But what happens if your application is rejected, you don't give notice of appeal within the 14 days which you've got when you're in country? You make an application for permission to appeal out of time, and that application is granted. Permission is given to appeal out of time, and your appeal does proceed up to the upper tribunal. Or indeed, going back a stage, if you get a refusal of your application and you don't appeal within 14 days to the first tier tribunal, then of course, again, permission can be given to appeal out of time. What happens though to the period in between when you were out of time for giving notice of appeal and the point when you're granted permission to appeal out of time? Surely this is a period when you don't have any leave at all. And that could have repercussions at some future date if you think you're eligible for indefinite leave on the long residence route. There would be a period when you had no leave, which could interrupt the continuity of your 10 years lawful residence. Well, this was the question which came before the Court of Appeal in Akinola, and the judgment was written by Sir Stephen Richards. So there are three possibilities for what happens when you run out of time for giving notice of appeal. And the first possibility is that your leave simply expires. Your Section 3C leave, because when you got the negative decision, Section 3C still kicked in, at least for 14 days. But if nothing happens within the 14 days, your Section 3C leave simply expires. And it doesn't get revived, even if you are allowed to appeal out of time. Section 3C leave has to be seamless, so it can't be interrupted. Now, a second possibility prevailed after July 2019 because of actually an unreported upper tribunal case called Ramshini, decided by upper tribunal Judge Lane, but not the president, his younger brother, Clive Lane. And he determined that an appeal is instituted when the first tier tribunal grants permission to appeal. And at that point, leave revives. Section 3C revives at that point when the extension of time is granted. Well, in fact, it could be quite a long time between your opportunity for appealing in time expiring. You then apply for permission to appeal, and then maybe much later, you're granted permission to appeal out of time. There'll be quite a long gap between when your leave expired and when it revives. Now, a third possibility was canvassed in the Akinola case itself, and that was rather optimistically saying that if your permission to appeal is granted out of time, that has the retrospective or retroactive effect of meaning that your 3C leave is reconstituted and in fact didn't run out at all. So although you didn't appeal in time, you're regarded as having appealed in time. Well, that's, as I say, a rather optimistic take on what should happen. And it wasn't approved by Sir Stephen Richards. Instead, he put forward a fourth possibility. And that is that your appeal is instituted not at the point when permission to appeal out of time is granted, but at the time when you give notice of appeal out of time with an explanation of why you're late, which could be a long time before you actually are granted permission to appeal out of time. Now, that still leaves a gap between when your leave actually ran out because you hadn't given notice of appeal in time and when your appeal is instituted again, or is instituted for the first time rather, by being granted permission to appeal out of time. So there you go. It's better than nothing, but as Sir Stephen rather hopefully remarks, the Secretary of State may exercise discretion in your favor to mitigate the disadvantages of a gap in relation to this out of time appeal. Something similar to what she also does with withdrawn decisions. Well, now, I better just check how we're doing for time, because I'm supposed to finish at 20 past 10. Ah, I do have another 10 minutes, so I can come to the topic of amazing grace. And this is the grace period provided now by paragraph 39E of the immigration rules, which has a close connection with section 3C. Now, we've been talking about Section 3C extending leave in situations where you've made an in-time application, that application is refused, and your leave would normally come to an end because the original leave has date for the expiry of that leave has been passed, but you've got the extra 14 days in which to appeal. If you don't appeal within 14 days, your leave expires. But you have under paragraph 39E, you have a further 14 days now in which to make a fresh application if you want. And that will be disregarded if you ever come to the situation where you want indefinite leave on long residence grounds. Now, it used to be a 28-day grace period, where if you missed the boat for giving notice of appeal, you had a longer period of 28 days in which to do it. Now it's just 14 days. But up until November 2016, you had 28 days. And as you'll see in paragraph 276B about granting indefinite leave on long residence grounds, both of those scenarios are taken care of in subparagraph 5 of paragraph 276B. Okay, well, we're going to have a look now at a case called AFSAL, which was promulgated at the end of last year, and does give a lot of hope to people who might have floundered in the past. Now, this will involve us going very quickly through the previous case law about overstaying and long residence. And first of all, everybody's heard of Hoke in 2020, and that's where Lord Justice Underhill drew a distinction between bookended and open-ended overstaying. So basically, if you had leave in the past, your leave ran out, and you made an application out of time for further leave, and that application was ultimately successful. If your out of time application was made during the grace period, then the period up to the grant of further leave will be disregarded if it comes to an application for settlement. It's also sometimes called interjacent overstaying. The overstaying takes place between two periods of leave, so that makes the overstaying book-ended. It's different if you make your application for indefinite leave at a time when you don't have leave, and you may have an application pending for further leave, but you don't have it yet. So you're still a person with no leave. You're an overstayer. So that's open-ended overstaying. You don't yet have a period of leave granted to make it book-ended. Now, if it's book-ended, the period of interjacent overstaying can be very long indeed. And in the case of Munib Asif at the upper tribunal, it was 18 months. So that can be done. However, there's been a recent Court of Appeal case called Wakarali that explains that you can only use the grace period once. If you make an out of time application during the grace period, you actually are in tune with paragraph 39E. If you can see, if you're following my case notes, you'll see an indented paragraph in smaller print, which actually quotes another Court of Appeal case, very similar, called Calci, makes the point that paragraph 39E permits an applicant who has overstayed for a short time to make a further application. It does not extend that applicant's leave, and so does not extend the period within which an application can be made in time. So the in time application was your earlier application. You didn't appeal against the refusal of that application within the 14 days. So your appeal is out of time, but the decision against which you're appealing, that is a decision on an in-time application made while you had leave. But if your application for leave is granted, you can't then make a third application if your second application is refused. But let's come on to the real meat, which is in the AFSAL case, and I'm just going to have to take you through, and it's a bit of a slog, but I think you'll see how this works if you just follow me for 5 minutes in the final couple of pages of my course notes. So if you come to the bit which we're coming back to AFSAL, if you can see it, and it says that the applicant here, his leave was due to expire. He made an in-time application to extend it, but he didn't pay the health surcharge. And he was notified by the Home Office he had until the 22nd of November 2017 to pay it. He didn't. And on the 22nd of January 2018, he was notified that his application was invalid. Now, within 14 days of that, Mr. AFSAL made a fresh application on the 2nd of February. And that application was eventually granted in September the following year. Now, as far as Mr. AFSAL was concerned, his leave had been extended by Section 3C until he received an adverse decision on the 22nd of January 2018. He then had 14 days to make a further application, which he did. So this was bookended overstaying. The Home Office view was no, his application for leave should have been made straight after his leave expired on the 14th of July 2017. But the application was not valid because the health surcharge had not been paid. So an invalid application doesn't extend the time under Section 3C. So his leave ran out then, wasn't extended, and by the 28th of November, 22nd of January 2018, it was well after his last period of leave. Now, there was some discussion about the Supreme Court case of Mirza, when one of the appellants before the court, two of them had made invalid applications. They were invalid ab initio. The third applicant had paid her fees, so her application was valid ab initio, but she didn't make an appointment for her biometrics to be taken. It was at that point when her application became invalid. And it was argued that something similar had happened in Afzal's case. But no, that was wrong. And the Court of Appeal here concluded that the time for making an in-time application was that it was by the 22nd of November when notification was given that the application was invalid. Oh, sorry, when it actually ceased to be valid. It ceased to be valid on the 22nd of November, although it wasn't notified as being invalid until the 22nd of January following. But in fact, it's not when you're notified that an application is invalid. Regardless of the notification, invalidity occurs by operation of law, which could be at an earlier date, as happened here. But then finally, and I am coming to the end, sorry, rushing through it rather quickly, but do read it at your leisure. Sir Patrick Elias proposed an alternative way of looking at it, which hopefully is the one which people are going to use, and it'll be accepted by the Home Office, that although failure to pay your application fee by the deadline invalidates the application so that your leave can't be extended by Section 3C, if the word application were to be construed so as to include invalid applications, and if the concept of refusal were to include the rejection of an invalid application, then in Mr. Afzal's case, the notice given to him on the 22nd of January 2018 that his application was invalid was the refusal of a previous application for leave, which did trigger a grace period of 14 days for him to make a fresh application, which he did do. And therefore that meant that when his application was finally granted in September of 2019, the whole of the period between January 2018 and that date was interjacent overstaying. It was bookended. The only drawback is that although that period is disregarded for the purposes of deciding whether you have a good claim under the long residence rule, it's not disregarded for calculating the 10-year period. You can't count this period of bookended overstaying towards the 10 years. In fact, Mr. Afzal's interjacent overstaying was almost 2 years, and he couldn't count that towards this 10-year period with continuous lawful residence. So he had to wait for nearly another 2 years before that period would have elapsed, thereby allowing him to apply for settlement. Well, I'm sorry I've rather had to rush towards the end. It is rather complicated, but do read through that at your leisure. And I've got a little, meant to be an amusing tidbit at the end of my talk called Surprise, Surprise. Fortunately, I mistakenly also put it at the end of my other talk, a miscellany of mistakes. So don't worry, you haven't missed out on that. And I think at this point, I had better hand you over to Sarah. I'll endeavor to deal with any queries if you've put them in the chat box while Sarah is giving her talk. So look out for that if you've made some queries. And at this point, I'll hand over to Sarah, who'll be talking about, I'm afraid, long residence. I hope I haven't stolen too much of your thunder, Sarah, but I think you can probably explain things rather better than I have. So I'll hand over. Thank you.
Thank you, Richard. I don't know about that in terms of better explaining it, but we'll certainly have another crack at it. Let me just see. I don't think my video, sorry, my video, I did. Can you see me? Can you see me, Richard? Sorry.
Oh, yes, sorry, I was muted. I can see you.
Okay, fine. Sorry, I just can't, it's not showing for me. I think it's just because I chose a different setting. Sorry about that, everybody. And if I could have power to share my slides, I don't think that was given to me. So if Thurindu's listening. There we go. So just bear with me. Sorry, I'm working from a new machine, so it's not quite. I've got to change my settings. Apologies, everybody, just bear with me. Thought I was well organized as usual. There we go. Hopefully you should now see my screen, and I'm just going to put that in slideshow mode. And hopefully I am there, and with apologies again for the slightly messy start. So good morning, everybody, and thank you, Richard, for starting us off so well. I'm going to be talking to you now on long residence. So as you heard from Richard, there is a bit of an overlap with Afzal. You'll see I called Afzal a beast of a case. Richard called it a slog. I think that is probably testament to Richard's much more tolerance for patients than mine, but we'll see, as I said, how we get into that, because it is a complex technical judgment with all sorts of issues in there, as you heard, in terms of validity and so on. But I've extracted the bits, I think, that are relevant in terms of the long residence, and we'll see. I don't think it's the end of it either. So long residence with a sprinkling of ETS and TOEIC, depending on how much time we have. Again, as you may know, in terms of my style is, and as is Richard's, there is much more material in the notes than we're able to speak to. So hopefully that's useful for you going forward and to look in your own time. The ETS, I've also given quite a lot of background, you'll see. And so again, we'll see how much time we have to get into that. So in terms of the talk, I'll cover first the 10-year long residence. As a bit of a roundup, I realize that you are no doubt very familiar, very conversant in the 10-year lawful residence, but I think it's useful every now and then to just take a bit of a refresher and just to sort of highlight the sorts of issues that we need to look out for, particularly in, as I've just touched on, this sort of shifting landscape in terms of case law. Then we'll look at the case law in a bit more detail, but focusing mostly on the last one. Sorry, my mouse keeps moving. Focusing on the last case of Afzal, and then, as I mentioned, ETS and TOEIC roundup at the end. I thought to combine the two subjects as much as possible, because I think we are seeing one or the other come up in the same context. So the ETS TOEIC cases are coming up to 10 years residence, whether lawful or not is obviously what needs to be engaged with. But similarly, 10-year lawful residence may have then been affected again by ETS. So you may have both issues going hand in hand and needing to be addressed on that basis. And then practical considerations will look all the way through as much as we can. Okay. So in terms of the rules roundup for long residence, we all know paragraph 276b, it's there, it's been there a long time, 276a in terms of capital A in terms of the definitions as well. So what we're looking at, as you know, is continuous and lawful residence. Okay, so it's that interplay, and you'll see in the case of Afzal that distinction in terms of the two definitions was also sort of reiterated and focused on, and I think it's important not to merge the two. You could have a continuous period of residence, so residence that's not broken for the purposes of this definition of continuous residence, but that continuity may not mean that it's lawful. Okay, similarly, you could have a large chunk of lawful period that's then broken by a particular event, and it's therefore not continuous. So again, this may sound quite basic in terms of going back to the rules and those definitions, but I think it's important not to lose sight of those. And here I've just on this slide just tried to summarize the main elements of each definition. So starting first with lawful, so leave, broadly leaving, starting first with continuous, and that effectively means that broadly leaving the UK is still okay, as in it won't necessarily breach, it won't stop, break a period of residence, but there are certain conditions to meet, and you have those just here in the sub bullet points. So you have permission to be in the UK when you leave, so you've got extant leave when you leave. You do not remain outside of the UK for more than 6 months at one time, so that's an unbroken period of 6 months or more than 6 months. So if it's 6 months exactly, that would be okay. And you've got permission to be in the UK when you return. We'll see in the later slide that there's some guidance in the context of visitors leave on that basis or in that context that's useful to also bear in mind. Here I've just also highlighted the Home Office guidance for you, long residence. It's useful to go back to really each time you make an application or you advise on this, in my view. Again, firstly, it makes the rules, it reiterates the rules, it words the rules in slightly more approachable language, but there can be, and as we've seen in cases so far, there can be sometimes more generous positions in the guidance than in the rules, and whilst that may not necessarily influence the application of the rules by the Home Office or in an appeal, the fact that there may be more generous provisions there or a discretion to be exercised can also be relevant if you're arguing articulate. Okay, so just bear that in mind, and it's useful to go back to. But again, that just reiterates the absences that are relevant also in the period of long residence. So you can't be, again, absent for more than 6 months at one time, but then a total of 18 months within the 18-year period. And then there's a reference to the change in the rules on the 24th of November 2016 affecting there as well. So turning to lawful residence very briefly, again, it tends to be what it says on the tin in terms of having existing leave to enter or remain. I've put /permission there because that seems to be the new language that we're dealing with in the rules when new rules are coming in. So permission to stay, for example. So that's obviously straightforward. But then there's just two additional types of status that are considered lawful and are provided for in the rules themselves, and that is that you are granted TA, so temporary admission, but where the leave is subsequently granted. So it might be an asylum seeker, for example, granted TA at the port, and then a period of leave is granted that would validate the whole period. Exemption from immigration control, again, you see that really mostly in the context of armed forces, but also diplomacy. And so again, that may be relevant for longer periods of time. And so we now start to move on in terms of the case law body And because of the constraints in terms of the short period of time that we have on this topic, I'm not going to go through, the sort of body of case law leading up to where we are now. And you have that in detail, as we've just heard in Richard's notes and Richard speaking to them just a moment ago. So do go back to that. What I tried to do was a bit of a shortcut. So acknowledging the free movement post on this, which is useful with where you have all of the hyperlinks there, and it was just a bit of a snapshot in terms of the sort of developments, major developments that we had, which I thought was useful. So the first one is already out of date, as you've heard, the difference between book-ended and open-ended overstaying. It's not necessarily out of date, I should qualify that, because there is still this sort of concept of book-ended and open-ended, but whether you can count those periods for long residence is what we'll look at, and what you've heard Richard touch on through the AFSAL case. And effectively, that's referring to the case of Hock here in the first bullet point. The second is the maximum number of absences that someone can accrue over the 10-year period. So if we go back to my previous slide, sorry, 2 slides, here, this period at the bottom, so the penultimate bullet point that you have there, spent a total 18 months outside of the UK throughout the whole period. So basically, this second bullet point here, maximum number, we needed a reported judgment from the upper tribunal to tell us that 18 months effectively amounts to 548 days, or rather the period of 18 months in that appellant's case amounted to 548 days and not 540. The background to this, and I'm sometimes a bit phased as to why we need a reported judgment to give us this sort of guidance, but it just goes to show again sort of what sort of jurisdiction we're working in. But effectively, the Secretary of State, as far as I recall, added up 18 months by basically taking 28 days, I think, and timesing that by 18, reaching 540. I think that's what happened, or maybe 30 days times 18. Someone with better maths than me might be able to work that out in their head. But effectively, the upper tribunal, or rather the appellants argued, and the upper tribunal found in their favor that you've got to add up the actual number of days that a person is absent for. You can't just take a month, the various complete months, and round that up to 28 or 30 days, whatever they had used. You've got to take the actual number of days. As we know, different months have different numbers of days, and that's how that rationale was reached. So I say, why do we need a reported case to tell us that? It should be fairly obvious, but again, it just goes to show that these cases are very precise, and you need to look at the case-specific circumstances that you've got and what absence you're dealing with, and painstakingly working that out. And with reference to that, just a small note, you don't count the day that a person leaves the UK, and you don't count the day that they come back in. So that's the same for naturalisation applications, where you have this exercise as well. And the logic for that is obviously you've left the UK on day 1, but you were in the UK on day 1. So you don't count those days, and it's only the days in between. And the third bullet point comes back to Hock, which is what has now been superseded. So already post, that's not that long ago, has shifted. And so it's important, again, in this area of law to become, very disciplined in checking for updates, seeking specialist advice if you think you need that. So we come on to just a bit more of a snapshot into a couple of the cases, and the one that I'm going to focus on first before we turn to AFSAL is the case of Mungur. So that is just a reminder, effectively, that you can rely on initial visits, or on visits in the middle of a person's residence, for example, even after they returned back to their home country or wherever they were traveling to. And so that's that can be, depending on your case, a useful addition to obviously the period of 10 years that you can look at. So it all turned, as I said, in this case on an earlier visit. So I won't summarize the facts for you, but you can look at them if it's relevant to a case that you have. And effectively, the person had come for a visit, at the start of a 10-year period, had spent some time in the UK, had then gone back and had then come back with a more, I won't say permanent, but a route that implies more permanency. And perhaps I think it was as a student, which often you have, certainly, 10 years ago or longer ago, persons coming initially for a visit, checking out colleges or whatever, then coming back and then going back and then coming back with a different form of entry clearance. So this person's 10-year continuous lawful residence could only work with counting that initial visit. If they didn't count that initial visit, they were short, as far as I understand. And effectively, the Home Office said, no, you couldn't count that initial visit. They argued that the temporary nature of a visit visa meant that the appellant fell foul of 276 capital A, little a, Roman numeral 3. And that stated that a continuous residence is broken. So it goes to the continuity of it, not the lawful, because obviously a visit visa while you're here would be lawful status, is broken if the person, and you'll see there, left the UK in circumstances in which he could have had no reasonable expectation at the time of leaving that he would lawfully be able to return. Okay, so I used to see that a lot in my caseworker days prior to the bar. I used to advise, no, you can't count that visit. It will fall foul of this requirement. So that's how long, these rules are sort of, sorry, I'm giving away my age, but, these are long-standing rules that are still being stretched, still being interpreted, still being pushed. So again, it's a useful reminder that it's always worth trying these arguments if you think there's something in them. And effectively, the court held that all visas short of indefinite leave to remain are temporary in nature and require the person to leave the UK upon expiry. So there is nothing especially precarious about a visit visa. So here, query whether we would have had that interpretation prior to, for example, the whole concept of precarious leave that came in with Section 117 of the Nationality Act in 2002. So that came in with the Immigration Act in 2014, I think. That brought in the definition of precarious status and kind of derived from European court jurisprudence on, well, if you've got precarious status, your private life can have limited weight, or we shouldn't give weight to a relationship established, or we should give little weight to a relationship established when leave is precarious. And then we had all of the case law in the UK as to, well, what does precarious mean? And I think one of the cases even said, well, indefinite leave could be precarious because you could have that revoked on the grounds of deception or good character, whatever. So query, I think, we sort of come round full circle, and in that sense, it's right. We can't have on one hand, guidance saying that if you've got anything less than indefinite, your leave is precarious for the purpose of Article 8, and on the one hand, for the purpose of sort of an expectation at the time of leaving that you would be able to lawfully return, not applying in this context because, visitors is precarious. So it's interesting to see, obviously, those developments, again, if you like to track these things. But effectively, it found, as I've just said, a visitor's visa is temporary. So why should it have sort of less of an expectation than any other form of temporary status? And the court held that the Home Office argument was an attempt to persuade the court to divine, and that's a word cited from the judgment, the meaning of the rules from alleged policy consideration. Sorry. Sorry, my mouse is instead of the plain meaning of the words, okay? And just continuing, the court was being asked to accept that a visitor's expectation of being able to return to the UK on a different visa cannot be reasonable. And the court found that the relevant definition in terms of that reasonable expectation is concerned with the person's expectation for the future, not the nature of any past lawful residence. So you're looking at, again, in the context, coming back to the 10-year continuous residence and looking back at the context of the long residence rule, obviously you're already dealing with a situation where somewhere in that 10-year period there's a visit visa, and obviously a bit later on there's another form of leave, because obviously otherwise you're not dealing with the 10-year continuous residence. You're not looking at the point of return once the person had gone back to their country or their country of residence and were seeking to return. You're not looking at it at that point. You're looking at it 10 years on potentially, or 5 years on, whatever the situation is. And you have then obviously the confirmation that they were presumably able to obtain a form of leave already. So that, you know, again, when you think of it that way, I think it seems quite obvious, but obviously it took Court of Appeal case to determine that. And so again, it's a useful reminder that visit visa periods can count. Obviously it depends on the period of time that they were here in the UK, and then it depends on the period of time where they were out of the UK, because you remember another part of the definition of continuous residence is that you're not in the UK for more, outside of the UK, sorry, for more than 6 months at a time. So if you had a visit visa and then 6 months and 1 day out of the UK and then they returned as a student, then you wouldn't be able to count the visit. But if they returned within that period of 6 months with a student visa, then you would be able to count it. So it's a useful snapshot to yeah, it's a useful aspect of a person's immigration history to bear in mind. And just at the end of the last bullet point is you have another reminder in this case. I haven't touched on it in detail, but just flagging here for you is that a person can claim a historic period of 10 years residence. So it doesn't have to be immediately prior to the application that they're making on the grounds of long residence. So if a person had 10 years continuous lawful, then left the UK for one reason, so you may have that maybe in the TOEIC cases where following the TOEIC refusals, they cut their losses or they were removed and they just decided to leave. I've had enough. But then they had 10 years lawful. If they come back to the UK, they could potentially claim that. So it's a useful reminder that it doesn't have to be immediately prior to the application or within a certain period prior to the indefinite application. And so we come to AFSAL. So I think I've got, 20 minutes left. So I'm not going to spend too much time on AFSAL because you've had a snapshot already through Richard's talk, but it is a beast of a case. So I stand by that description, certainly as far as I'm concerned. I've highlighted there, it does link up with Mirza, which was another beast of a case, which I didn't actually go back to, I couldn't face it. But just bear that in mind, they might need to be read together to sort of make sense of this as well. And looks, as you heard Richard mention, it's all in the context of validity / invalidity and in the context of the immigration health surcharge. So I won't touch on the validity aspects of it. You've had Richard's talk on it. You can delve with it in that further if you need to. And so the relevant to the long residence is the penultimate bullet point. It finds that the court finds that whilst book-ended overstaying does not break continuous residence, neither can that period be counted towards the 5 or 10 year qualifying period. Okay, so it looked specifically at Hock. It found what Hock said in terms of the disregard provisions and how bookended is still okay for lawful residence to one side on the basis that Hock was looking at it obiter. So yeah, that's, I mean, it's useful perhaps in terms of the continuous residence, but not the lawful aspect of a period, and does obviously take us back, winds us back a bit in relation to progress that had been made on the lawfulness of a residence and the interplay with the amazing grace, which is perhaps not as amazing anymore in terms of its application for the lawful residence provisions. The court analyzed, to get there, the court analyzed the wording of disregarded. And so I've just highlighted in the judgment, it's at paragraph 56, if you want to make a note. It's quite a good kind of way of getting our heads around this. And it says, the court says, in my view, or rather in Elias's view, the natural meaning of a period being disregarded is simply that one should not have regard to it. It should be ignored. It is important to note that in paragraph 276, capital B, little 5, it is not the fact of overstaying which is to be ignored when paragraph 39E is engaged. Rather, it is the period of overstaying. That is so with respect to both open-ended and book-ended periods of overstaying. Okay, so looking at the period of overstaying and whether that can be counted, and in AFSAL, the court said no, as far as lawful residence is concerned. So moving on to the next slide. It does, in my view, represent a significant departure from Home Office practice and policy. Obviously, those that got in off the back of Hock and had their ILR granted, I had a couple of cases that benefited, great, and they got it. Those that sort of pre-Hock had not got it, but then Hock helped, may have then been able to correct the situation. But now, obviously, we have a bit of a question mark in terms of where this takes us for long residence lawful applications. As I understand it, AFSAL is seeking permission to appeal, and I asked one of the barristers representing the appellant whether there's any update on that front. I haven't heard back, so if I do, then I will communicate via the conference organizers, and perhaps an update can be sent out to those who attended. But effectively, what I thought in terms of practical guidance is useful to bear in mind while we perhaps await further guidance is going back to the previous case law concerning validity of applications, because if the issue that led to the break of residence or to the overstaying is a validity issue, so you made your application in time, it was rejected as invalid, that was left as it was then for whatever reason, and then a fresh application was made. By that point, the person is an overstayer. It's then granted. That's that period that's tricky now. So I'm just flagging here, by no means it's a foolproof solution. It will be case specific. It will be depending on the arguments that may or may not have been run at the time of the invalid application, why they weren't run if they weren't run, and so forth. So there's so many variants there that it's hard to follow it all through theoretically. But I just thought it'd be useful to flag the old case law of Basnet and Mitchell. There will be also accompanying Court of Appeal cases, but there may be something there where you can argue that the application actually wasn't invalid, and so therefore the leave should have continued. I had a case recently where that was an issue, so I can't remember exactly the period, but it was an invalid application from 2015 or so, and then the person had leave later on, and there was a dispute as to whether that application was invalid or not. And I think the other consideration to just think about is, even if your arguments on the invalid application or valid application doesn't follow all the way through in relation to making it fit for the long residence rule, so lawifying, if that's the word, but basically validating that period as sort of retrospectively lawful. If you can't make that work, you can't sort of box that circle. It could still be quite weighty considerations on the Article 8 front. So if a person actually there's a query as to whether they can meet the long residence rule because of this issue, but there's a good case that actually the application in question was wrongly rejected as invalid, then, you know, I think historical injustice, those sorts of arguments could come in under Article 8. So I think it's worth, you know, looking at quite carefully. And the last bullet point, whether it will change or not in relation to, in reaction to the case law, is do keep, as I said, an eye on the Home Office guidance, because you may find something useful there that you could look into either on Article 8 grounds or seeking discretion. So we've got 15 minutes left to reach ETS. So I hope that's not too much of a short roundup on the long residence front and the case law of AFSAL. The ETS TOEIC context. So we'll just for now shelve the long residence guidance. But as I highlighted at the start, I think they are, you know, coming up now in relation to, you know, long residence claims. If you recall, ETS sort of blew up in February 2014 was the Panorama, I think, airing that started all of this. So, you know, that's shy, you know, 8 years ago. So anybody who had lawful status, which they would have had pre-ETS issues as a student, presumably, and is then caught up in ETS, may be coming up easily for 10 years, or obviously has clocked 10 years and is still sort of fighting for their rights and their status, and for potentially still fighting this allegation of fraud and deception. So I think it's useful to think of them alongside one another as well. But another reason why to bring all of the ETS stuff up now is very timely. Last week we had BBC news articles and a Newsnight piece on ETS, and a whole load of question marks again being raised, and the spotlight again being shone on the way the Home Office dealt with it at the time, the way they've been dealing with it all the way through, the way they are still dealing with it. So I would highly recommend you, if you haven't already, to read that article. BBC News is hyperlinked there in your notes, so you can access it. The Newsnight piece also, it's available on the iPlayer. It's you know, pretty depressing, but very useful stuff. And again, a follow-up article from The Guardian, also from Amelia Gentleman, who you may have heard of already in the context of Breaking the Windrush scandals. So, you know, I think it's quite telling that she's touching on this as well. Again, by no means do we have all the answers and we know where this is going, but the article and the piece in Newsnight again focused effectively on a, you know, whistleblower, on how the Home Office, you know, gave ETS the job of investigating its own problem. So, you know, that's questionable in itself. But a lot of the issues that this brings to light are issues that we've been arguing, either as practitioners or that the clients have been arguing. It's been issues that perhaps have also been held against the appellants that now are questionable with this news piece. For example, I have a colleague, Lawrence Yousefian, actually, who you heard if you attended the last conference in October. He's presented a few times, I think, now. And he has a Court of Appeal case pending on ETS, where the appellant, his client, they went through all of the evidence in terms of the client's evidence of what they remembered about the test center on the day, you know, all of the events leading up to that, all of the account that they passed the test, that they sat the test themselves, with a view to countering, obviously, the sort of more generic evidence of the Secretary of State citing the fraud. And the first-tier judge found against the appellant on the basis that they didn't find it credible, they didn't find it plausible, that the appellant, if they had sat the test themselves, would not have noticed anything untoward at that test centre on that day, on the basis that the Home Office had given the statistics of all of the tests that had been found invalid on that day. And so the logic was that, well, if fraud was happening on the scale that it was pursuant to those statistics, then the client or the appellant should have noticed something. So that's held into question now with this news piece, that it would have been very difficult, this whistleblower said, for persons to have known what was going on, and again calling into question the methodology that was utilized in order to reach the finding that a test was invalid and therefore fraud had taken place. So that's the sort of, we're still dealing, as I'm sure you have in your own practices and with your own classes, we're still dealing with clients that are still fighting to clear their name, to fight the allegation. It's all compounded as well by the lack of statutory right of appeal in many cases. So that's just 5 minutes on why I think it's important, both on the long residences coming up, but also these news pieces, I think, do throw up a huge amount of questions. And I think it's definitely not the end of it in terms of what we'll see come out of them. And so in the second half of this slide, I've just tried to summarize for those that might be less familiar with this area, the sort of the key findings, or the sort of the key stages that we've reached through a growing body of very complicated case law. So I summarize there the Panorama investigation, effectively finding that there was large-scale fraud at the ETS centres. And there was a system devised where if fraud had happened, the test, the certificate would become invalid, and the result would otherwise be questionable if it wasn't conclusive. So if there was quite large scale fraud of the centre, for example, that might then put into question some of the results, even if there wasn't evidence of fraud themselves. And it then later emerged that the Home Office created a third category that was found in Kadir, or tracts recorded in Kadir, where again those tests at a centre where there were numerous invalid and questionable results. A reminder that the onus rests on the Home Office to prove that the appellant is guilty of deception. It's important not to lose sight of that. But again, SM and Kadir in the Court of Appeal explained, or sort of tracked again, clarified that that burden can shift. So initially there's an evidential burden that the Secretary of State needs to discharge. So, put something forward to support the allegation of fraud. You can't just, just say, well, you cheated and offer nothing in support of that. If you don't offer anything in support of that, then you haven't discharged the evidential or the legal burden. But if you offer something in support, you may have initially discharged the evidential burden, and then the focus sort of switches to the appellant to see if there's anything to rebut that, to see if there's anything to put that evidence from the Secretary of State into question. So that's SM Kadir, and then we'll see later Shahzad has confirmed that as well. Gravity of the allegation is such the Secretary of State is required to prove that allegation to the requisite standard. The second bullet point, the stronger the allegation, the stronger the evidence is required, is perhaps in some quarters quite controversial. I think it very much depends on the judge, on how they sort of understand the burden of proof, the standard of proof. It's by no means meaning that stronger the allegation, they've got to prove it to the standard of beyond reasonable doubt. We are still within the realm of balance of probability, so the lower standard, the civil standard of proof. But there is quite a large body of case law supporting the submission that if it's a serious allegation, then you need to have cogent evidence to support that. So again, the flimsier the evidence, the more difficult it would be in arguably for the Secretary of State to discharge the legal burden of proof. But I've made that submission in the past, and that's been interpreted by judges as me trying to say that it's a higher burden of proof. But it's, I think, useful to engage with that and cite the relevant case law if that's helpful in a particular case. Then I've just tracked the sort of evolution, I suppose is the right word to say, in terms of the Home Office's evidence, because it started with what has been termed now and recorded as such as generic statements from Rebecca Collins and Peter Millington. Okay, and this the reaction to this evidence was sown in the judicial review case of Ghazi. So it already concerned the court was already concerned there with a lack of detail in the Secretary of State's evidence. But I think because, again, this is from memory, because obviously it's already 7 years ago, this case, there was not much progress perhaps attained about that because it was within the context of a judicial review. Then we come back to SM Kadir, which I've mentioned already. And this is a citation from the judgment that the Secretary of State seeks to make good this allegation to the requisite standard by adducing evidence in addition to the generic evidence noted above, which is the statements from Rebecca Collins and Peter Millington, which you will have seen if you've done any sort of ETS cases. A flimsy spreadsheet emanating from ETS, which in a single line contains in substance only the name of the student concerned and the categorization of either questionable or invalid. So that was sort of at the start of what we had. So at first it was sort of just this generic set of statements. Then we had a flimsy spreadsheet with just one line of basically, you know, the date of the test, the name, and then as that's just said, categorization of questionable or invalid, which was what was supporting their allegation of fraud. And there was expert evidence for the first time, I think, from the appellants in SM Kadir that criticized the methodology that had been presented so far on behalf of the Secretary of State. And so on the generic witness statements, the UT found by an admittedly narrow margin, we are satisfied that the Secretary of State has discharged this burden, which is the evidential burden. And the effect of this is that there is a burden, again, an evidential one, on the appellants of raising an innocent explanation. So that's when we started to make a bit of progress. I say we just generally, as I wasn't involved in any of these cases, but as a community in terms of lawyers fighting these cases, dealing with these cases, putting forward the clients and the appellants' positions on this. And this is where we start to introduce, you know, the appellant's own evidence that they can actually respond to what the Secretary of State is saying by giving detail of their test center, by giving detail how they booked it, by giving any evidence that supports that, by giving their evidence in terms of the test and what they recall and so on. And so that's going to the innocent explanation. Sorry. Oh, sorry. If I hover, I don't know why it moves it. And it's happened again. I'll sort this out by next time. So SM Kadir, as I mentioned, held that the further evidence is that further evidence is needed to discharge the Home Office's legal burden of proof. So it's not enough to have the generic witness statement. It's not enough to have the one-line Excel sheet if you then have a fairly good account, credible account, consistent from someone who, you know, in the vast majority of cases has not been involved in any form of bad faith or any form of good character issues and so on. That was then upheld by the case of Shahzad by the Court of Appeal. So again, reiterating where the generic evidence is not accompanied by evidence showing that the individual under considerations test was categorized as invalid, I consider that the Secretary of State faces a difficulty in respect of the evidential burden at the initial stage, okay? Then we had the case of Hassan, so that's in 2017. And again, query where these sorts of cycles come through, but query whether we would have this without carrying bin loss, but also whether we would have this in the time of remote hearings that we've now crossed with the pandemic. But effectively in Court of Appeal, the in Hassan, the Court of Appeal sowed the seed in effect to consider whether or not out-of-country appeals, which is all that a person would have, is the right forum for persons to fight the allegation, to deal with that, and for the courts to deal with that, to determine that. But it didn't go any further because it wasn't dealing with the case with that issue on point. So we then turned to Khan and others, which is the most sort of key recent case. It's not the most recent case, but it's the one key case which I'm going to leave you with. It's very important, and I say for various reasons. I say that for various reasons. The first is it can, if you succeed in dealing with ETS through a statutory appeal by having perhaps made a fresh application in that sort of route, and you successfully deal with the ETS allegation on appeal, then Khan says the appellant should be put back to where they were before the allegation was raised. Okay, so coming back to the long residence context, it can effectively cure a person's messy immigration history as a result of ETS, and as a result of, for a very long period of time, not being able to get to a tribunal, or perhaps having abandoned JRs because the case law at that time wasn't favourable, and that can all sort of be cured in effect. But the second important reason to stress Khan is because it doesn't seem to be applied very consistently either by judges, in my experience, or by the Home Office. Okay, so if you know about it, you can assert it, you can use it. And I would not want to rely on the Home Office to bring that to bring that to the fore. I don't say that generally, it's been fine in some cases, but just be wary of that. And effectively, the whole issue of the rights of appeal came up, and the inability of persons to effectively challenge this allegation came up as part of Khan. Parties were agreed, so it wasn't a contested hearing in the Court of Appeal, but the Court of Appeal, because of the importance of the issue, the number of cases impacted on this, felt it was important to nonetheless give judgment. And it then summarized the terms of the agreement between the parties. Okay, and it was basically agreed that the appellant should submit full particulars of their human rights claims within 28 days. The Home Office would respond to those submissions with a decision within further 28 days. The Home Office would not certify those claims as clearly unfounded. If the appellants are successful at that appeal on the basis that they did not commit fraud, the Home Office will withdraw the decisions accusing them of fraud. Thereafter, the Home Office will grant them a period of 60 days by which you can make renewal extension applications or claims for ILR for 10 years, for example, whatever the case may be. And when making any future decisions on applications for leave to remain, the Home Office will not hold any previous gaps in leave caused by an erroneous ETS decision against an applicant. Okay, so you have that there in black and white to go back to. Now, the first part of those bullet points you may not need, because I think what is happening now is that the Home Office is doing that. So if you have a client who comes to you, they don't have any status, they're still lumped with this ETS issue, you can make a fresh application for them, and maybe the Home Office will continue the allegation of fraud, but you will no doubt have a right of appeal to then challenge that on human rights grounds. Okay, so usually that first step is there now. It's the second part that even when you're at an appeal stage, there's some debate as to what that entails. Judges, although they're considering an appeal only on human rights grounds, they need to engage with the allegation. And so you need a finding on the allegation. And so that's really one starting point. And really, there's no need to look at anything else, arguably, because the most important thing to cure is the allegation of the ETS. And once that's out of the way, we have confirmation through Khan that that refusal on the ETS initially could have been, 7 years ago now, 2015, 2014, 2015, as early as that. And that effectively should be treated as withdrawn, which would thereby cure that whole 7-year period, arguably. Okay, so that's why Khan, if you haven't used it already, you need to familiarize yourself with it. But even if you use it, you've used it already, don't stop using it, because again, in the long residence with now AFSAL, I think it's important to engage with it quite carefully so that we can effectively get rid of the refusal in the first place, and not argue about whether period should be disregarded and all of that. So if you can get back to the starting point, then I think the clients have much better chance to succeed in 10 years or Article 8 applications. So that's where I have got to. So I'm sorry I've overrun by 4 minutes, but I hope that was useful, and to try and make sense of some complex case law that I don't think I've still got my head around fully, but that's where we are at the moment. And obviously, if there's any questions, put them in the chat box, as Richard mentioned, but also we've got a panel discussion later on this afternoon, so we can look at anything there verbally as well, if anybody wants to ask some questions then. So that's it for me. I hope you found that useful. And I think we are on break. Is that right, Richard?
We are indeed, Sarah. Thank you very much. That was very useful to have a coffee break, I'm afraid. It was only 10 minutes. So we're ready to start with the third talk. Now, our next speaker was to be Jamila Hassan. She's been held up with a hearing that she had this morning. So Sarah has very kindly agreed to step in. She had already agreed to step in and do Samina Iqbal's talk on the EU settlement scheme, but and that was going to be this afternoon, but we are switching it around so that the talk about the settlement scheme will now be given by Sarah, and Jamila will give her talk this afternoon. So welcome to you again, Sarah, and you'll be giving an update on the EU settlement scheme using Samina's course notes. Thank you.
Thank you, Richard. And yeah, apologies for those that might not want to see me again. But yeah, we just had to switch around. So I've got apologies from Jamila. You'll see her later this afternoon. But she had a care case come in overnight. So there was an urgent issue that needed reacting to. So it had to be put into the diary this morning. And so she thought it might be resolved by now, but isn't. So let me just share my screen again, and I hope my mouse will behave a bit better. I spent an hour on a phone call with my dad last week, getting him to figure out how to plan a Zoom meeting. And I was complaining about it and saying how the pandemic and everything would be sorted by the time he gets his way around Zoom. And here I am experiencing techie issues. So just goes to show, and there is karma. But on a more serious note, Samina, again, apologies, wanted to join us, but she couldn't make it today, and due to unforeseen circumstances. And so I'm speaking to her notes on EUSS updates. So both of us actually have, I think, spoken on this topic for those that are regulars to this conference. So I hope I will do justice, but we also both felt when we were putting the talks together that it would be useful to have a bit of a roundup. I think previous talks were perhaps in anticipation of cases when making applications and so forth. And we are now dealing with appeals. We're now dealing with either late applications or perhaps refusals now. So it may be a good time again to do a bit of a roundup. What we've tried to do with this talk is to try and keep it as practical as possible. So there isn't as much gobbledygook in relation to the regulations, for example, because there's quite a few sets of regulations that apply, and every set of regulations is quite complicated and badly drafted. Same with Appendix EU and Appendix EUFP. It's really hard to navigate through. And so I haven't, you'll see that Samina hasn't extracted you know, too much of the law, but just we're trying to speak to the issues to try and help you navigate this area. And obviously, once you navigate it, you'll need to go to the source materials, which are also flagged in hyperlinks, but we just felt for the talk that it might be better doing it this way. And do feedback if you disagree, or, you know, if you felt that was useful, or if there's anything else that we need to bear in mind for any future talks on this issue, because by no means are we done with Brexit, done with these applications. I think for many years to come, we are going to be resolving this. So in terms of the topics covered, so EUSS in-country applications, so we thought we'd focus on that mostly because that's probably what you're mostly dealing with, but also the persons who have come from abroad since Brexit through applications for family permits under Appendix EUFP will have come and will then need to do their in-country application for the pre-settled status. So that's what we've decided to focus on. Again, also with the restraints of time, you could do a whole talk on joining family members and applications from abroad. So perhaps if you're needing that, feed that back to the organisers and we can time that for next time if you want us to. And then a middle section on problem cases, focusing in particular on extended family members and durable partners. So we'll look at that again, highlighting key issues around that and what to do about them. And then looking at really the grounds of appeal and the withdrawal agreement terms that are useful. So this is the sorts of stuff now that we're having to engage with, and then trying, obviously, as usual, to keep it as practical as possible. Sorry, let me just minimize the sun view. The first aspect is EUSS country applications. A roundup really of relevant dates. You should have this, but if you don't, then obviously it's there. And also previous slides that we did for these talks, if you attended previous conferences, are useful to go back to in relation to the Brexit day, you know, cut off for various EUSS schemes and so on. So I haven't transposed all of those again. But effectively, cut off for residence rights in the UK, we should have written here, Samina should have written here, for EEA nationals, EU nationals, okay? So that's really the focus on the whole, is 31st of December 2020. And that is, again, just by way of roundup, the end of the transition / implementation period. Those two terms are used. Brexit was on the 30th or 31st, I forget now, January 2020. Okay, so that was Brexit, but because of the transition and implementation period, we had the rest of 2020. Okay, so that's the focus. So if you have an EU national, EA national asking you about PSS, asking you about settled status, they needed to have, the first question is they needed to have been resident before the 31st of December 2020 in the UK, even for one day. Okay, there's no real limit on that. And it's residence, not treaty rights. Okay, so focus is on residence. If you have a family member, third country national family member, and they inquire, so they need to have had, if they're still married, their spouse needed to have been resident before the 31st of December. Okay, so that sort of test, if you like, that question can also apply to, I said I wouldn't focus on it, but could also apply to out-of-country applications. So you have a spouse who's abroad, they want to come and join the EA national, that's fine. Under Appendix E UFP, there's no deadline. Okay, comparing it to the schemes in country, that's fine. But the test is, was their EA national resident before the 31st of December 2020? Okay, so I can't say that enough. That should be your first sort of question. Now, there are exceptions. Of course, there are always exceptions, and it is particularly complicatedly drafted as well. So I've just summarized this. So please do go to the source materials, go to, you know, Annex 1, go to the guidance if you want to help, if you want more plain English and sort of easier prose to understand. and obviously seek specialist advice if you need to. The sort of general, at a glance, exceptions are continuous residence is broken. So if an EA national, for example, was resident before the 31st of December 2020, but left the UK and a certain period has elapsed, then that residence could be broken, and therefore the rights could therefore be in jeopardy. But there are again exceptions to that. So there were various exceptions made in relation to COVID and other reasons for the absences. So look at that carefully. The absences are on the whole fed into the rules now, but the Home Office guidance is a useful way in as well. So look at both. Home Office guidance there on the second bullet point is hyperlinks. Okay, so it will take you to it. A quick plug for Here for Good. So if you do a lot of EU cases, if you want to get into them, if you are mindful of needing to just be kept up to date in case they come up, two organizations to kind of keep your eye on is Here for Good and the 3 Million. So they are effectively not-for-profit that were set up as a result of Brexit, looking after the rights of EA nationals and their family members. They have both taken on strategic litigation since Brexit, some with success, some without. Here for Good was successful in relation to the EUSS COVID-19 guidance. There was a challenge to some of the limitations in that that was successful, and then the guidance was effectively brought into the rules. So they're useful organizations to keep an eye on. They have good websites, they have good resources. You can signpost clients to them. They host good webinars. All of their webinars, as far as I can recall, are also presented, if you like, delivered to lay clients, so are not overly legalistic. They have newsletters and so on that you can sign up to for updates as well. So I can't stress that enough. The other organization that I should mention is ILPA. If you're not a member of ILPA, I would encourage it. It's not too much the cost of the membership for an organization, so it would cover anybody in your firm or organization. And the European working group is also very good. So again, their updates are very good. And I think it's an area really where if you want to, if you want to do your client service, you need to stay updated. There are quite a few policy announcements or calls for policy changes that we can then use even if it hasn't yet changed, if that makes sense. So I think it's useful to stay up to date. Lastly, in terms of sort of general points and deadlines, as we know, the deadline for in-country applications was extended to the 30th of June. So at first it was 31st of December 2020, in line with the end of the implementation period. Then it was extended to the 30th of June. But you do also have exceptions. So of course there are exceptions as guidance on that. You can make late applications if you've got reasonable grounds for doing so, and your application is then made within a further reasonable period. So it's a two-stage, two-limb test, but obviously with focus in the first instance being on the first reason as to why your application is late. The guidance, I can't stress enough, is good, surprisingly so, if I may say so. We're used to the guidance on, overstaying or late applications being very narrow. Overstaying for a short period of time will be disregarded if there was a postal strike, if, you were seriously ill, admitted into hospital, that sort of threshold. This is very different and so very useful. There's lack of awareness being cited. So if you didn't know about the deadline of the 30th of June, the specific mention, if I recall correctly, that those with permanent residence under the regulations were not aware that they needed to also seek settled status. There's a lot of unawareness about that. That's specifically cited. Lack of IT, lack of internet for those perhaps living in more precarious circumstances. Those elderly applicants, like my dad, who's not very good with IT, or maybe I now should class myself in that. It really is, I can't stress enough how kind of much it covers. And there's still some also catch-all provisions that you could probably make fit. And then there's of course very specific circumstances that could also come under. So you have children in care, for example, where steps were not taken by the local authority, victims of modern slavery or trafficking, that sort of thing. So you've got very specific, very kind of compassionate situations, but you've then also got more run-of-the-mill circumstances that are thankfully covered for. And they have been, again, plugging for those organizations, they've been covered because of that campaigning, because of that, you know, awareness raised about the lack of awareness among certain communities in particular. So do go back to that if you have to make late applications. It's very useful. And a plug, I think it might be here for good, I forget exactly what organization is in relation to some pending litigation. So there's a situation where we're seeing now some developments where EUSS applications have been pending a long time for those that have, for applicants who may have pending prosecutions or issues of good character. And there's something in the pipeline on that front. So if it's applicable to one of your cases, I just wanted to highlight that in case you were not aware. Okay, so let me just check I'm on the right side. Yeah. Then I just thought to highlight, again, just finishing with the general points, really a few things that come up now that we're sort of in this process a bit more with clients making applications or having pending applications, clients coming in and out now that may not have been resident before the 31st of December. So the first point is just to highlight that if you have an application under the EUSS in country, but you wish to travel, the applicant wishes to travel outside of the common travel area. So common travel area, basically the UK and Northern Ireland, and I think the Republic of Ireland is defined in the rules if you need to check it. So effectively, you know, let's say a French citizen has their pending application here, they want to go back to France for some reason, they can. And their application will not be treated as withdrawn. So that's the EUSS applications are one exception to the normal rule that's in the immigration rules that an application will be treated withdrawn if you leave. Okay, but bear in mind, obviously, an applicant could be a third country national. They might not have any form of extant leave if they do leave. So there may be an issue in coming back. So don't get too gung-ho when giving that advice, and do check and make persons aware. If they are married to an EU national, they may still want to travel, because obviously they could still make an application to come back, and that may be you know, the alternative that is okay for them if they have urgent reasons to travel, for example. But just be aware of that. As far as I can tell, the provision for that is in the guidance, which I've given you the page for. I tried to find it in the rules and I couldn't the other day. I was asked a question on behalf of a client. I thought it was in the rules. It should really be, if it's an exception to this. It may still be. I ran out of time and couldn't then continue searching, but you do have the reference there to the guidance. Then the second bullet point is in order to highlight that we do need to start changing our mindset, and I certainly haven't managed to do so fully. And I still catch myself thinking along, you know, along pre-Brexit days, along pre-end of implementation period. So I just wanted to flag that. So post 31st of December 2020, if an EEA or an EU national, Swiss, etc., comes to the UK and they were not resident before, then they are coming effectively as visitors. If they want to come for another purpose as a visit, they should be seeking the leave to do so. Okay, so if they want to come and study, they should be seeking student leave. But if they're coming to enter the UK to visit, whatever, then they get 90 days permission from the time of entry. Okay, that is not necessarily endorsed, because you can pass through the e-passport gates as well. So that again compounds a bit maybe of a lack of understanding from those European nationals who may not be aware of this, because there's no physical endorsement of this. So just be aware of that, because if an EU national comes, you know, last year October or earlier this year, that is their condition of stay. now, 90 days from entry. If they're then going back, it's fine. You know, there's no issue with that. And it's the same for us Brits going to France, for example, 90 days permission to enter, unless you have residence rights over there. But again, it's important to bear in mind, depending on any future applications, because if obviously that period of 90 days is overstayed or not clocked at all, you know, there can be issues further down the line. Importantly, we flagged this, I think, on a previous talk, but importantly, previous restrictions on visitors switching into PSS and settled status were removed in the rules. And I think that's from October of last year. I didn't double check it, but there's now provisions directly in the rules in Appendix EU that you can't be refused just because you've got visitors leave. So that can be useful for either European nationals who maybe had a residence broken, a period of residence that was broken, but come back. They're treated as visitors to begin with, but actually they've got a claim due to historic residence that perhaps wasn't broken after all. Otherwise, it's also useful for family members. So if they came here as visitors, so either European national family members or third country, they can still assert their rights through Appendix EU if they're here as visitors. And the last reminder that you may or may not be aware of is you can no longer travel to the UK just on your national ID card, unless that person, the EEA national, the EU national, Swiss national, has pre-settled status or settled status in the UK. Okay, so any others, so French national never came to the UK before, wants to come and visit to the UK, they will need a French passport. Okay, they can't travel on their national ID card alone. However, someone with PSS or settled status can. And I suppose that relates to the first bullet point, that if a French national has their EUSS pending application here but wishes to travel to France, then yeah, they could. It doesn't mean their application is treated as withdrawn, but you need to make sure they have a passport, for example, because when they come back, they wouldn't have PSS or settled status already, because that application may still be pending. Okay, so a few considerations there now that go beyond, you know, whether they have status or not, but relating to what travel document they can use, you know, and so forth. So just now entering a bit more into the, just checking the time, into the types of in-country applications that we are dealing with. So I've just covered, obviously, the applications for PSS and settled status as European nationals, family members, again, glossing over it really. But you then have a different category, which is the joining family member. Okay, so if you were the former categories, EA nationals, close family members here already in the UK, your deadline for application was 30th of June. Of 2021, and if it's beyond the deadline, you need reasonable grounds and putting it as fast as possible, basically. This category, joining family members, are those granted a family permit under Appendix E UFP to come and join, says what it says on the tin, come and join a family member here, so come and join in the EA national, for example. They may come after the 30th of June, so there's sometimes confusion you know, in relation to that deadline for in-country applications of 30th of June 2021. So if they made an application last year, they may not have come until, you know, December of last year, but it's fine because there's provision for them. And those provisions are usually, so again, just look at it very carefully in case there are exceptions that you can make use of, or if there are actually earlier timeframes that you need to be dealing with. But usually the deadline is 3 months from the date of entry in the UK. So if they came December 2021 with their family permit, they should be making an application for pre-settled status off the back of that within 3 months of their entry. Okay, again, that may coincide with the expiry times on their family permit, or it may not. Sometimes they are issued for 4 months, sometimes they're issued for 6 months, as far as I can tell. But usually the deadline is 3 months from entry, so just be aware of that. And then some pointers Worth checking, rights to work guidance, right to rent guidance, those have sort of changed. Those have changed with COVID as well simultaneously. So there was a concession due to COVID, I think, where rights to work checks were not necessarily mandatory. But I think that's sort of all, you know, as we're coming out of restrictions, that's being reviewed. So I flagged this because, again, there's a campaign on behalf of the 3 million, I think, for those who had PSS but convert to settled status. When their application, I think this is right, when their application is pending, they've got no means of proving their PSS status. And I think that's still the case, because the whole formal check is digital. When somebody has an application pending, I think the digital check defaults to the pending status of the application rather than the pending status of the PSS. Something stupid like that, something avoidable, something incredibly frustrating, but I think something that's still not resolved. I think query and double check that. But that's the sort of thing that as representatives we can point to, if ever, in terms of the employers, the right to work guidance, that sort of thing. Right to rent, again, is relevant now because EU nationals are, you know, subject to immigration control in effect. So again, it's a bit of a change of mindset and needing to apply all of this guidance to them as well. And I just flagged the specific guidance for EU, EEA national students, again, because of that change of mindset that's needed. So we get to the nitty gritty with 20 minutes left. Yeah. And then to the sorts of grounds and the sorts of arguments that we can try and raise. So the first bulk of cases, the first sort of major category that's problematic is extended family members. And those of you already working in this area will be familiar with this, so forgive me if it's repetition for you. But effectively, the reason for that is because extended family members were not provided for post 31st of December 2020. Okay, so there's no saving provisions, there's no sort of retained EU law as far as extended family members are concerned, unless they have an application pending that they submitted on the 31st of December 2020. At broad brush sort of summary, okay? And that is really applicable to an extended family member, to use the term loosely, when seeking to come from abroad or here in the UK. And at this point, I'm not putting durable partners in. Okay, so by extended family members, I mean anybody who's not what we used to know as a direct family member under the regs, anybody who's not a close family member, as the definition in Appendix EU, and anybody who's not a durable partner. Okay, so we're talking uncles, aunts, brothers, sisters, cousins, any other form of sort of wider family member relative to the EEA national or their spouse. We can put into that category in-laws as well, not parents or grandparents, but sisters-in-laws, brothers-in-laws, that sort of thing. Daughters-in-laws potentially as well. Okay, or sons-in-laws, I don't mean to gender it and by limit it that way. So that's who we're dealing with here. And so if they've made an application before 11 o'clock, and 11 o'clock's important to note because with online applications, obviously you can submit it before 11 p.m. despite the postal services being closed. So it's important to clock the time by 11 p.m. on the 31st of December 2020. If that person made a Regulation 8 article as an extended family member, then they're provided for. Obviously, they still got to prove that they meet the regs requirements and all of that, and we're not going to go into that for today, but they are then saved. So as long as they've got their application pending, they've got rights. If that application is then refused, they've got a right of appeal. But if they haven't made that application by the 31st of December 2020, 11 p.m., then there's issues, okay? Flagging at the fourth bullet point, a concession, which again seems obvious now, but there was a lot of debate in some quarters. And that is those that made applications before the 31st of December that were refused, either pre or post 31st of December, it doesn't matter. They then appealed, and because of COVID or lengthy waiting times or both, they did not have their appeal heard until like last year. And then that appeal wasn't allowed until after or even before the 30th of June 2021, but it was then not acted on by the entry clearance officer. So whatever the sort of timescales were, we had a situation where entry clearance officers and the Home Office was arguing in appeals. What's the point of these appeals? After the 30th of June 2021, they were saying, I think that even was debatable, but they were saying that we could not issue a residence card or a family permit to allow the person to come into the UK. So they were effectively saying, even if the appeal is allowed, we've got no way in law to legislate for it to provide for that. So there was a lot of debate on that front, a lot of appeals that were left, unimplemented, and there were delays and there was lobbying, etc. So that resulted in, I think, October of last year, this concession being announced. It's in page 21 of the Home Office guidance. And effectively for now, it's a concession that's operated outside of the rules, which addresses that situation. And they can come with, I think, a letter, or, there's provision made for a bespoke document to be issued to them so that they can come to the UK and then they can have their status renewed upon extension, and the same applies to those who are here already, extended family members. Presumably they could then have an application treated as sort of all in order under the Appendix EU. Okay, so again, a bit of a mess, and has been resolved by, quite frankly, another mess. And so it's still a bit unclear. It was announced in October that it would be first a concession outside of the rules set in guidance, and that in further time that would be built into the rules, but I think we've yet to see that come into the rules. So there seems to be, plenty of energy to bring in changes of rules when it comes to deportation or, criminal convictions, and that's done very fast. But when we have these sorts of situations, time is taken. So that's as far as I go with my comment, but just be aware of that. And so we come to just a couple of body of sort of scenarios on extended family members, which is that you do have situations, and I've come across them personally, and same with colleagues, where cases are made, mistakes are made in certain cases. And for example, the extended family member or the relative who saw themselves and it's as an extended family member made an EUSS application before the 31st of December, so made an Appendix EU application, or made an Appendix EU FP if they were abroad, instead of a Regulations 2016 application. And that, they say, is a pure mistake. So we've seen that quite a few times now, and they're coming up to appeal now. I think those are arguable, and we'll look at the arguments in a second, but I think we've yet to see how successful we are and what the approaches the courts take. But effectively, you've got, again, guidance that you can pull from in terms of a lack of awareness that I've talked about in relation to the 30th of June deadline. On the drop-down menus, it's quite hard to tell, as a lay client in particular, that you're making an application as a close family member under Appendix EU, or you're making an application as an extended family member under Regulation 8. So there can be mistakes made at that stage. For one period of time, also, if you can clock this, you can then find the goods, if you like, to support such a submission if it's relevant in your case. But for a period of time, the online Regulations 2016 application was not available, I think, and it was only paper applications that were there. So there's all sorts of permutations and variations that can happen. But if the application, whatever that application was made before the 31st of December, then I think you've got arguments that we can take forward, and we'll look at those very shortly. The applications where the application was not made before the 31st of December as a pure extended family member, and it was made later, are trickier. And I'm not going to go into that for today. But you need to look at fact specific. Why was it not made by then? What's the situation? If they're here, it may be more straightforward because they've arguably enjoyed residence rights, or have impacted on the residence rights of the European national already. If they're abroad, I think that's trickier because they've not really been resident alongside the EU national here, and so any impact on the EU national could be harder to argue because the status quo is that they've not been living together. So you can have different scenarios, some stronger, some less so, if the application was not made by that deadline. And of course, there may be attempts to bring in articulate considerations as well. So it's very fact specific, and we'll need to leave that for another day. So that's extended family members. And I'm just going to turn, before we look at to what sort of arguments we can look at after, because we're going to look at the arguments in the context of both of these categories. So durable partners, again, another problem category, in my view, unnecessarily so, and perhaps even more unnecessarily so than extended family members, because durable partners, as we know, are much more common, with marriages perhaps not happening for a variety of reasons than perhaps 10, 20 years ago. So durable partners, they are only provided for if, again, they have a pending regulations application that was made before the 31st of December, or there are certain exceptions relating to continuous residence being broken, but also relating to having that durable partnership recognized by the issuing of a residence card before the EUSS application was made. Okay, so effectively, again, if you apply now as a durable partner for the first time, whether Appendix E, UFP, or in country, there's issues. Okay, and so really, again, durable partners need to relate it back to the period pre-implementation period of the 31st of December. So just flagging it in those terms, really, because again, the minutiae needs to be engaged with, the nitty-gritty needs to be engaged with. But if you can log, if you're not familiar with this area, that there's more complex procedures relating to durable partners and potentially difficulties. And the logic for that is at bullet point 3, and that is, in European law, when it comes to durable partners, the duty was only to facilitate an application, and for that application to then be looked at, an extensive examination of the personal circumstances. So it's in contrast to the rights of family members as a spouse, where the minute you're married, you acquire residence rights, and you can assert those residence rights as long as your marriage is not one of convenience. But a durable partner needs that recognition from the Secretary of State for the rights to kick in. Okay, so the only right that you can insist on is really the right to make an application, the right to have that application facilitated. Okay, I've cited the most recent case that touches on this. It's not directly on point. It's the case of Singh, which I think Richard covered earlier this morning as well. But it confirms the only duty is in relation to facilitating applications. There are other more, not very old, I think they're 2020 and 2019, other cases that confirm that in the context of the period of time that a durable partner can acquire permanent residence under the regulations. So 5-year qualifying period for permanent residence under the regulations. And I think a durable partner had tried to claim an earlier point in time when that they were in the relationship, but that relationship had not been recognized by the Secretary of State. And the tribunal said, no, you can't. You can only count from the time of the issuing of the residence card, and it's 5 years from then. Okay, that's the same logic It's only the time for the issuing of the residence card. And that's important because I still see persons asserting their rights as durable partners when they didn't have the residence card, and that's tricky. Okay, so that time needs to be validated in effect. The penultimate bullet point, if subsequent marriage, so if the durable partner hadn't had that relationship recognized by the Secretary of State, but subsequently marries, then they can still qualify under Appendix EU, even if the marriage, definitely if the marriage is pre-implementation period. So they were here as a durable partner forever, they never made a regs application, they then married, they managed to marry in summer of 2020, for example. Well, no, they wouldn't have married in summer of 2020 because of lockdown, but let's say they married in autumn of 2020, one of the few that managed, then they are fine. Okay. The problem category extends to those durable partners who didn't have their relationship recognized if their marriage is post implementation period, so 2021 onwards. Again, they can qualify, but really if they only had their durable partner recognized before. So again, there's various permutations. You need to engage with that carefully. Okay. COVID-19 impact on marriages. So I've touched on it already in terms of the example of 2020 not being really good because of lockdown. This is why this is cropping up a lot of the time, because people may have realized the need to marry in genuine relationships, but may not have been able to. And all of this is compounded with the EUSS deadlines running alongside, obviously, the period that we've been living through this pandemic and all of the restrictions that entails. ILPA have formally raised it with the immigration minister. So that was a letter in January, I think early January, 5th of January, 7th of January, something like that, saying provision needs to be made for this group that were partners that married and they married late, or maybe they're still waiting to marry because of the backlog. So watch that space. The letter's available there for disclosure, but only if your family, if you're ILPA members. So I couldn't share it widely as part of this forum, but if you're ILPA members, you can access it through their website. And again, watch the space as there's bound to be some developments. So I've got 5 minutes left to run you through fairly complex arguments that are available or up for grabs, and certainly up for development as we work through these cases. So I'm just going to flag really the sort of the rationales against this. But I mean, I think I've done 3 skellies now. One in the context of durable partner, I had a hearing on it yesterday, and 2 in the context of extended family members that applied by mistake abroad before 31st of December under EUSS as opposed to the regs. So I've done 3 skellies. All 3 skellies have ended up being like 15 pages long. And all 3 skellies took me an eternity to do each time. So, you know, like, I don't profess to be an expert. I don't profess to have all of the answers, and you know, any of this at my fingertips. So, you know, we all need to take care and time on this. So I think as long as we grasp that, then again, we can work through this. But yeah, forgive me if again, I'm complicating things by trying to take you through it in 5 minutes. But effectively, you have several Brexit regs. So here's one of them cited: Immigration Citizens' Rights Appeal, Regulations 2020. Okay, that's the first set of regs, I think, in time, and effectively deals with EUSS applications made in country that carry a statutory right of appeal. So I cited from this. This regulation, I think, should be mirrored, though, in the others. But it's useful because matters to be considered by the relevant authority. Relevant authority will include a judicial authority if you're dealing with it on appeal. And little 4 I thought was useful. The relevant authority may also consider any matter which it thinks relevant to the substance of the decision appealed against, including a matter arising after the date of the decision. Okay, so, you know, applying, for example, to marriages, you may have had a marriage happen since the refusal, but before the appeal. Query whether you can make that fit. And now we turn to the withdrawal agreement. So for those that are newer to the area, the withdrawal agreement is the treaty, the piece of legislation that governs the terms of the UK's withdrawal from the EU. Okay, it will cover all sorts. It's a huge document. Access it on HTML on the website so that you can just go to the sections that are relevant to you. But I mean, it covers like energy, it covers all sorts of stuff. But the sections that I've cited here are the ones that relate to in our context of immigration. Okay. Article 4, I usefully didn't cite paragraph 1, and I'm not sure why now, or rather Samina and I aren't sure why. But effectively it says that paragraph 1 says the withdrawal agreement has direct effect. So in the same way that EU law before had direct effect in the UK, the withdrawal agreement has direct effect. Okay, so if you're worried with the Home Office citing, you know, some form of other regs that perhaps are not in line with the withdrawal agreement or even the immigration rules, and you're worried that they're not actually reflecting the withdrawal agreement, it's the withdrawal agreement that has direct effect. Okay, so that's important to remember. And then the rest of Article 4, I won't read it out, it's there for you to engage with, effectively confirms that the UK, in applying the withdrawal agreement and applying the terms of the agreement, has to abide with union law and the concepts as part of that. So it has to be Court of Justice compliant, etc. And that, again, takes precedence over any domestic stuff. Article 10 is where you have the scope of who's covered by the withdrawal agreement in terms of resident status and residence rights and family member rights. Okay, so it's extracted here. It's not all of it. It's quite a long article. But effectively it applies to union citizens that were residing before the end of the transition period. So that's where that comes from. And then I've extracted the sections that relate to these two problem categories of extended family members and durable partners. So little 2 here you have persons falling under those paragraphs, of Article 3.2 of the directive, which is effectively other beneficiaries, that's the term used in the directive, and persons that don't fall into Article 2, which is the direct family members. They are covered if their residence was facilitated by the host state in accordance with national legislation before the end of the transition period. So those extended family members that have residence cards, that had family permits, those durable partners that had the same, they're covered. Paragraph 3, persons who have applied for that before the end of the transition period are covered. So that goes back to what I was saying earlier. You know, the problem arises if you haven't made that application by the 31st of December because you're in no man's land at the moment. But where I want to stress Article 10 here is by facilitation of entry and residence before the end of the transition period. So I'm just going to stress that timescale there and speak to that in the next slide. If you come under those categories that I've just highlighted, paragraph 5 confirms that you should have your personal circumstances extensively examined by the state. In order, sorry, the second part is useful, in order to justify, any denial should be justified, okay? Article 18 is in relation to the issuing of residence documents. So that's a useful one to look at as well. And I'm going to finish on that very quick note. The time period, the time frames are provided for in Article 18 and can be extended. So you have a little b already at the bottom of the slide. The deadline for submitting the application shall not be less than 6 months from the end of the transition period for persons residing in the host state before the end of the transition period. So going back, for example, to durable partners that may be married after and didn't have their status as partners recognized before, but married after the 31st of December, if they're here, the withdrawal agreement confirms that applications generally, in general terms, can be made within 6 months of the end of the transition period. That's what led to the extension, if you remember, as where we started with this talk. That's what led to the extension of time to the 30th of June 2021. So the logic, in my view, is, well, how can we then have a restriction in here in Article 10 that before the end of the transition period has to be the 31st of December. But if they then applied before the 30th of June, which is provided for, how do those two marry up? So I think there's an argument there. Again, it requires the person here to have made the application before the 30th of June. But then again, you know, you could perhaps stretch it further. There's provision in the withdrawal agreement for reasonable grounds to make a late application. I didn't cite it here, but you have it in Article 18. I think it's C and D. Again, provision in the withdrawal agreement for late applications. So going back, sorry to flit again, but going back to this previous article, Article 10, in terms of who's covered by it, if you are covered because you've had an application facilitated by the state, which they have to facilitate within 6 months of the end of the transition period, or if there's reasonable grounds, then that should be read purposefully, basically, with the spirit of all of this. Okay, so in that sense, you can try and kind of stretch those dates to make it work. And then the last part, I think, yeah, the last part of the withdrawal agreement that I wanted to focus, it's still in Article 18, but it's little o and little r. And that is that the competent authorities of the host state shall help the applicants to prove their eligibility and to avoid any errors or omission in their applications. They shall give the applicants the opportunity to furnish supplementary evidence and to correct any deficiencies, errors, or omissions. That, in my view, squarely helps those applicants that made applications before the 31st of December 2020, 11 p.m., but made the wrong one. Okay, so extended family applying under EUSS for the first time, not having had their rights recognized before, durable partner, again, applying under EUSS instead of the regs. That squarely helps them, in my view. That puts the onus on the Home Office to have sorted it out or to have contacted the applicant. Okay. Not always accepted. That's my view. It's not been accepted in every tribunal that we've argued it so far, but it has been accepted in some. And in little r, the applicant shall have access to judicial and, where appropriate, administrative redress. So basically providing for statutory rights of appeal, which they have. But here's the important bit, highlighted, underlined, and with a big fat red disproportionate highlighted. The redress procedures shall allow for an examination of the legality of the decision, as well as the facts and circumstances on which the proposed decision is based. Such redress procedures shall ensure that the decision is not disproportionate. So if you just bear that in mind, in terms of everything arguably being checked and balanced, if you like, against a proportionality principle, we know that proportionality principle was ever present in EU law. I'm not talking Article 8 balancing exercise, I'm talking proportionality balance with regards to steps taken by the state and whether that's proportionate. Okay, and so insistence on over technical kind of details with regards to having a relevant document, with regards to having had a relationship recognized when they had tried to have it recognized perhaps, but not in the right way. That sort of argument comes under here, I think, as well. So you've got support there. So I'll leave it there. Apologies again for overrunning by now 8 minutes. And I hope that that was useful to sort of provide a way in. I will stop sharing now. And is not too much of an overload. I think there are some questions in the chat box, but we'll deal with them in the panel discussion. And I think the last thing to take home that I've stressed already is we're just working through this. So, bear that in mind in your own practices as well. But we need to work through it is I think what's clear.
Thank you very much, Sarah. As your talk has plainly demonstrated you really are an expert
Well,
on
actually, yeah.
EU law, and we've all benefited very much from your account and all those slides. So thank you again, and you're now off the hook, aren't you, for the rest of the day? And indeed, we'll all be off the hook for a while when the lunch break comes along, but I'm afraid that won't be till 1 o'clock, folks. You've got to put up with me again, but I promise my next talk will be not such heavy going as the first one. It's a miscellany, so I'll be ranging over lots of different things, but not spending too long on any of them. And I hope I might be able even to say something amusing. Let's see. Well, we start off with some curiosities that have come my way when taking part in appeals against the refusal of family permits or residence permits, mostly under the 2016 regulations, but which are still going through the appeal system at the present time. I had a curious altercation not that long ago with a solicitor who had put an application in for what he called a European family permit, which had been refused. And I asked him, European family permit, what sort? AEA family permit or EUSS family permit? No, he said, European family permit. Oh, I said, well, what was the relationship then between the appellant and the sponsor? Oh, he said, the appellant is a close family member of the sponsor. Oh, I said, what exactly? Oh, well, his brother is married to an EU citizen and he's very close to his brother, so he's a close family member. Oh dear, turned out that he was an extended family member, not quite the same thing. But the application had actually been made inadvertently under the EUSS rather than the EEA family permit route. And because the applicant was an extended family member, the family permit was refused. Well, that's the first thing on your course notes on page 3. Notice I'm using the page numbers now. Next is something which was quite curious, but isn't so lighthearted. It's the curious fact that now that we've got video link hearings as the norm, not just in immigration appeals, but throughout the court service generally, you might have thought that now that we're used to it, why don't we have participation by appellants against the refusal of entry clearance? They could join the proceedings by video link as well. So why don't we do that in the immigration jurisdiction? We don't, because of a case called Nair, dating back to 2011, in which Mr. Ockleton said that participation by electronic means by a witness who's not in the courtroom should only be granted in exceptional circumstances. In fact, he was talking about communicating by telephone rather than by video link. Yes, it was that long ago, 11 years ago. And participating by video link would have been a very unusual and exotic thing to do. However, in later appeals, a few years after that, when the Secretary of State started certifying particularly deportees, people who were foreign criminals and who were liable to deportation, she was certifying their appeals so that the appellant could only appeal from abroad by video link. An experiment was started at Taylor House just a few years ago to see how it would work to have a hearing by video link. And I think it was in Kingston, Jamaica. And that was a reported decision a few years ago. Anyway, the whole business of trying to appeal from abroad was examined by the Supreme Court in Chiari and Beinglass, you may remember, in 2017. And there was, although various problems were identified, including the hassle about getting permission from the overseas authorities for that to happen, that didn't really feature prominently in the judgment, which was more to do with the difficulty of instructing a lawyer and keeping in touch and so on. Anyway, in an appeal in which I was involved, much to my surprise, on the morning of the hearing, when I joined the video link, much to my surprise, were the 4 appellants who had been refused EEA family permits. They were mother, father, and 2 adult children, and they were all resident in a faraway land. But they had been told that they could come and take part in the hearing. Well, the judge was just as surprised as me, and there was a discussion in which he drew my attention to Nair and said that I would be granted an adjournment to seek authorization from the country concerned for these 4 appellants to give live evidence by video link. It had to be done via what used to be the Foreign and Commonwealth Office and is now the Foreign, Commonwealth and Development Office. And it turned out that I had to go through a thing called SOP inquiries. What is SOP? Well, SOP is service of process. And indeed, there was communication with the service of process officer in the legalization unit of the FCDO. Legalization, not to do with drugs, I guess. And he told us that the Foreign Office could only assist in civil and commercial proceedings and would not currently provide assistance for tribunal hearings where the government is a party, though this was set to change with the establishment of taking of evidence inquiries. Well, we didn't get permission, or we didn't get authorization for these faraway appellants to join us at the resumed hearing, which was several weeks later. But despite the fact that no authorization had been given, they turned up again. So the second judge told them that he wouldn't be able to hear from them, but they would be able to sit in and observe the proceedings, just that they would have to mute. So it went ahead without their participation. Well, what's the current state of affairs? In a very recent upper tribunal case called Ababiaka, Mr. Justice Lane has given further guidance on hearing evidence from abroad by video link, but the guidance doesn't change very much from there. The only thing it says that's different is that live evidence doesn't have to be given from a courtroom or hearing center, which was one of Mr. Ockleton's stipulations in Nair. But we still have to get permission from the authorities of the country concerned via the taking of evidence unit. And they can let you know if there's anything on their books about whether in the past 5 years a foreign country has objected to the giving of live evidence from its territory. If no such check has been taken hitherto, a check can now be made for a consular fee of £150. So there you go. Moving on down towards the bottom of page 4, I won't dwell on my ignorance of matters digital, but I will go back to problems with EEA family permit and similar appeals or for the appealing against refusal of a residence card for an in-country applicant. And nearly always, in my experience, applications for an EEA family permit have been refused because not lack of remittances from the sponsor in the UK, but lack of any evidence of the appellant's actual circumstances in the country where he's living. The Home Office want to know what are his, what other potential or actual sources of income he has, and if he really needs the sponsor's remittances to meet his essential living needs. And nearly always no such evidence is forthcoming. Sometimes the reason is that country X has a cash economy and invoices and receipts are not exchanged or given. So there's nothing printed or in writing to show purchases which are necessary for the appellant. Oh dear. Also, things can come to light in the course of a hearing when there is a hoppo and the hoppo is cross-examining the sponsor, which were not revealed at the application stage, such as the appellant wants to join his cousin or brother, whoever, in the UK, but he'll be leaving behind a wife and children who were never mentioned before. What about them? Oh, well, as soon as he's settled in the UK, he's going to call them. But in the meantime, if they do come, I mean, even if they were to come now, would the sponsor be able to put them all up? Because it's sometimes overlooked that dependency or household membership must not only be established in the country of origin, but also it must continue when the applicant arrives in the UK. He's got to be either dependent or a member of the household of the sponsor. So that can be a problem. I've tried an argument, not successfully, when the sponsor has a particularly low income, to say that, well, his relative abroad must really need that money for his essential living needs, because the sponsor would never be sending all that money if it's just to keep this relative in the lap of luxury. But I'm afraid that argument hasn't worked very well. Just while I'm on the subject of curiosities at this appeal stage, I keep seeing grounds of appeal drafted by solicitors against the initial refusal of the application, which say in their grounds, the decision is not in accordance with the law. The decision is not in accordance with the immigration rules. A discretion should have been exercised differently. Wow, those grounds of appeal were abolished years ago, remember? You can only appeal now on the basis that the decision violates the Refugee Convention or the Human Rights Convention, or, well, that's about it really, isn't it? Apart from appeals against deprivation of citizenship or European appeals. Yes, so there we are. On to something less lighthearted, age assessments. Now, these are, in fact, age assessments were the very first kind of judicial review that the upper tribunal was allowed to take on a few years ago. And they were very hard work. Well, they still are, because it's difficult really to establish within any reasonable limits how old an asylum seeker might be who claims to be a child. And unusually for judicial reviews, a decision has to be made as to whether the applicant is or is not under the age of 18. The Home Office has got two sets of guidance for its own caseworkers or immigration officers. One is called, near the bottom of page 5, Assessing Age, and there are also the enforcement instructions and guidance. Now, in the latter, there is a criterion for assisting in the assessment of age, which says that if the applicant's physical appearance or demeanor very strongly suggests that they are significantly over 18 years of age, and there is no other credible evidence to the contrary, that can mean that they're not accepted as under 18. There also has to be a conclusion to that effect by two Home Office officials separately coming to that conclusion. Well, there was a recent challenge to this Home Office policy characterized by what's called Criterion C, which I just quoted. And this was based upon the approach that appearance and demeanor are inherently unreliable indicators of a person's age. And reliance upon this policy was unlawful. Now, this was accepted by the Court of Appeal after the applicant failed in his judicial review before the upper tribunal. But the argument was accepted by the Court of Appeal. But when it got up to the Supreme Court, the Secretary of State won. The Supreme Court did not accept the Court of Appeal's view that the correct approach was that, or rather that the current policy created a real risk that more than a minimal number of children would be liable to detention because they were wrongly assessed as children, above the age of 18. One of the advantages of being accepted as a child asylum seeker is you can only be detained in very unusual circumstances. Plus, of course, you get looked after by your local authority, and you're in a much better economic position than adult asylum seekers. Well, the Supreme Court disagreed with that, and they said that the correct policy was established by Gillick years ago in 1986, and that is that the policy must not direct officials to act in a way which is contrary to their legal obligations. And of course, the justices conceded officials will go wrong, they will make mistakes, that they could be incompetent, but the remedy is to go to the court and not to make a policy which is really impossible to implement, because you can never eliminate mistakes completely. And so the Court of Appeal's suggestion, that's near getting towards the bottom of page 6, that immigration officers should be directed to treat applicants as a child if they believe them to be under the age of 23 or 25. Oh, well, that policy would certainly not have pleased the Daily Mail, which has been running some pieces recently about children in classrooms looking askance and somewhat timidly at strapping young fellows with a thick growth of stubble on their cheeks, sitting there when they're obviously not children at all. But there you go. There is now a proposal in the Nationality and Borders Bill to establish a national age assessment board, which would be responsible for assessing the age of asylum seekers claiming to be children. And appeals from the assessment of that board would not be by way of judicial review to the upper tribunal, but would be a statutory appeal to a chamber of the first tier tribunal. the bill doesn't actually specify which chamber. It may not be the Immigration and Asylum Chamber. If it is the IAC, the first tier tribunal would really not be accustomed to the kind of thing that's involved in JRs for age assessments. It would be quite heavy going for them, I should think, to begin with. Anyway, there's been another recent JR. This was in the administrative court, in which a policy allowing fast-track age assessments was deemed unlawful. Now, this policy was being applied to migrants who arrive in dinghies across the English Channel, something which again has been much in the newspapers and on TV in the last few months. And this was carried out, the assessments were carried out by social workers instructed directly by the Home Office. They were expedited assessments, not using the Merton compliant process, which was established some years ago. They could refuse to accept an asylum seeker as a child if there was reason to doubt his claimed age. So that was a lower test than the one approved by the Supreme Court. Now, moving on again, but still going with the Nationality and Borders Bill, we have something which will not be acceptable at all to immigration practitioners, and this is the establishment of, or the return of, fast-track appeals, which were declared unlawful in 2015, you may remember, by the Court of Appeal. So what is proposed now is that anyone who is liable to removal or deportation, pretty wide, can be the recipient of a priority removal notice, which will put him into an expedited process. Now, this is likely to affect not everybody, but people making or trying to make fresh claims, having already been refused once and having lost their appeal. So if their further submissions are accepted under paragraph 353 of the immigration rules as constituting a fresh claim, they can then have this priority removal notice slapped on them, and they have to provide their information and evidence by a cutoff date, or if they don't, they have to have a very good reason for not providing that information. And if it's not a good reason, that could damage their credibility. They must also respond a bit like the current Section 120 notice, if such a notice is served. They must respond by stating any other reasons they may have for staying on in the UK or not being removed. Now, the PRN remains in force for 12 months after that cutoff date. And if after the cutoff date, the person concerned makes a human rights claim, then the appeal, if that claim is rejected, will go directly to the upper tribunal, not to the first tier tribunal at all. Now, there's a precedent for that kind of thing. If any of you can remember back to the 1990s, I doubt if many of you are old enough to do that, but in those days, appeals against deportation on conducive grounds lay directly to the second tier of the appellate system, then called the Immigration Appeal Tribunal. And the first tier, the adjudicators, were not involved. So it went straight to the second level of the appeal system during the 1990s. Now, not only will these expedited appeals go straight to the upper tribunal, there will not be an avenue of appeal to the Court of Appeal. So there'll only be one opportunity to appeal in those circumstances. Now, you may remember more recently, there was another attempt to oust the jurisdiction of the higher courts. And it was under Tony Blair's administration, but it provoked a huge response from the higher judiciary, as well as from immigration practitioners, and it was dropped in the end. There was opposition also in Parliament, particularly the House of Lords, and maybe there'll be a similar level of opposition to these proposals, particularly in the House of Lords, before they get through. Anyway, that remains to be seen, but with such a large Conservative majority in the House of Commons, it's likely that most of the proposals in the bill will get through. Now, the bill also tampers with one of the convention reasons, not very much. It combines two separate definitions of what it means to belong to a particular social group and fuses them into one. So on the one hand, you've got an innate characteristic which you shouldn't be expected to abandon, or a belief that's so fundamental you shouldn't have to give it up. And on the other hand, there's recognition by society in general of this social group. It has a distinct identity in that country. And the proposal is to combine the two so that it must be something so fundamental you shouldn't have to give it up. And people who have that fundamental characteristic or belief have to be recognized as such in the country of persecution. Now, onwards rapidly to nationality. Now that's being catered for, as in fact the last talk this afternoon by Joseph Byrne, but I just want to say a little bit about it myself. Now, Joseph will be actually dealing with the specific topic about giving notice that your British citizenship status is being taken away from you. Now, under the provisions for depriving a person of British citizenship, there is at section 40, subsection 5 of the 1981 British Nationality Act, provision for giving notice of this decision by the Secretary of State. So the recipient of this decision must be given written notice of it, of the decision, and the reasons for the decision, and of his right of appeal against it. But there is provision in the new bill for this to be dispensed with. Currently, it would be against the law to dispense with notice. And in fact, there was a challenge to a regulation which was brought in quite a long time after the British Nationality Act and the provision for depriving people of citizenship by the British Nationality General Regulations 2003, Regulation 10(4) of those regulations says that where the person's whereabouts are unknown, notice shall be deemed to have been given when a notice of the decision is put on the file. So notice that you're being deprived of your citizenship can be placed on the file, and that's it. Now, the Court of Appeal has held that that is unlawful. There is a there is an inconsistency between the statute, section 40, subsection 5, and the regulation, 10, subparagraph 4. And in the tussle between them, of course, primary legislation wins out. The secondary legislation is ultra vires, the enabling act. So at the moment, such dispensation with notice is illegal. But if you look halfway down page 10 on my notes, you'll see that one of the Lord's Justices in the appeal of D4 said this: if the government wishes to empower the Secretary of State in that way, it must persuade Parliament to amend the primary legislation. That is what it is currently seeking to do under the Nationality and Borders Bill, which probably will go through. And also it would have retrospective effect, so that a decision to deport somebody that was not properly notified to the individual would retrospectively become treated as being lawful, even if it was done before this bill becomes law. Going on to something which is much more common, thankfully, than being deprived of British citizenship, is being refused an application for British citizenship on the grounds of bad character. But you can also be deprived of citizenship, not because of joining ISIS or doing anything, seriously prejudicial to the interests of the United Kingdom, not Samina Begum type cases, but because you actually acquired your citizenship by underhand means. And the cases on that mostly involve people who had claimed asylum as being Albanians from Kosovo. They were recognized as refugees and later acquired British nationality, but it later turned out that they were from Albania all the time. They weren't from Kosovo. So they had won their British citizenship by false pretenses, and therefore they could be deprived of citizenship. Now, a recent case called Walile at the bottom of page 10 involves somebody who didn't practice deception on the Home Office when making his application. He got indefinite leave, of course, and he applied, as you'll see at the top of page 11, he applied for naturalization in January 2010. In May 2010, the application was granted, but some time after that, he was charged with a criminal offense. Now, if he'd already been charged with that offense before making his application, he would have had to disclose that on the application form. But surely, as the charge wasn't laid against him until after he'd made his application and the application was granted, surely he couldn't be accused of concealing a material fact, therefore justifying deprivation. But look what it says in the Home Office Guide AN in the indented paragraph. While the application is under consideration, we expect you to tell us about anything which alters the immigration you have given us. This includes police investigations or anything that may result in charges or indictment. Now, there was an investigation going on while the naturalization application was being considered. The applicant should have told the Home Office about these investigations. He didn't, and so they got him on concealment of a material fact. Now, let's move on very quickly to the immigration rules. Nishan Paramjorthy will be talking about that after lunch, but here's something that he hasn't mentioned in his course notes, and this is a very welcome addition to Appendix Skilled Worker, which came into force just today, the 15th of February. And that is some relief to the crisis in the care sector. There are well over 100,000 vacancies for care workers, both the ones who work in care homes, looking after elderly people, or the ones who go around from door to door, spending, usually that they're in a great rush because they've got so much work to do, helping elderly people residing in their own homes to do things like wash and dress and go to the toilet and stuff. So huge shortage of workers, and it's now going to be possible for people from overseas to be recruited as care workers. They don't have to have educational qualifications equivalent to the RQF regulated qualifications framework, level 3. They can be paid what is the minimum under appendix skilled worker, namely the hire of £20,480 per annum, or £10 10 pence per hour. Actually, £10 10 pence per hour for a 40-hour week gets you up to £20,480. Now, this is the kind of level you have for a living wage, which you'll see further down that paragraph is £9.90 outside London per hour and £11 5 pence per hour in London. So for the living wage, and without having any particular educational qualifications, people can be recruited from overseas to work as carers. The one thing they will need, though, apart from sponsorship, is level B1 English. So obviously they have to be able to speak reasonably good English to do that job. The government still insists that it doesn't want to have overseas workers being recruited except where it's absolutely necessary. And the immigration minister has said as much. Now, Kevin Foster MP used to be called the Minister for Future Borders and Immigration. Now he's the Minister for Safe and Legal Migration. Where do they get these titles from? Anyway, he's harangued employers by saying that they must continue to invest in training, opportunities and wages for the resident workforce to ensure that the UK's hard-working care workers get the type of rewarding packages they deserve. Now, here are two well-worn politicians' cliches for you. Whenever they talk about families, they are always hard-working families. You never hear about bone-idle families or scrounging families. And the voters should always get the top-class health service, education, schools, transport that they deserve. Oh, how come they deserve it? It always seems to me that Dr. Johnson had it right. If every man got what he deserved, who would escape whipping? Anyway, politicians don't say that. Note on page 12 that carers can't be obtained for private households or for individuals. Many households would love it if they could actually get somebody to live in as a carer whom they could recruit from abroad, but that's not possible. Only licensed sponsors can do that. I go on to talk about the youth mobility scheme. That's something which is on Nishan's list, so I won't say any more about it, except just to note that the youth mobility scheme has been widened to admit young Indian professionals. And unlike all the other countries which are eligible for this youth mobility scheme, Indian applicants must have either a university degree or they must have worked in a professional capacity for 3 years for an employer who can certify this. So the bar is being put much higher for them educationally. and they will get, in fact, the lottery for places hasn't yet opened. It has done, or it did do last month, January, for the other, there are 4 Asian countries which have to go through a lottery process in order to get onto the scheme. And that lottery took place last month, but hasn't yet happened for Indian applicants. And finally, just coming up to the lunch break, something for you about people with a derivative right of residence, and in particular, Zambrano. Now, derivative rights under the EEA regulations were not as good as they are now. Under the regulations, you could get a residence card, a derivative residence card, but it wouldn't lead to a permanent residence card. So that was always the threat that you would cease to be eligible for a derivative residence card and you would have to leave the UK. But now people with a derivative right to reside are eligible for the EU settlement scheme, and they can get settled status after a continuous qualifying period of 5 years. Now, how does this affect, in particular, Zambrano carers? The matter came before the Court of Appeal recently, and the court had to look at the definition of a person with a Zambrano right to reside in Annex 1 to Appendix EU. This was described by, yes, Lord Justice Underhill, my favorite Court of Appeal judge, as elaborate to the point of impenetrability. I love that. It may remind you of what Lord Justice Jackson said a few years ago about the immigration rules. He said that they have attained a degree of complexity that would be the envy of a Byzantine emperor. Hard to disagree. Anyway, one of the requirements in Annex 1 for a Zambrano carer is that they should be without leave to enter or remain in the UK, unless it's leave granted under Appendix EU. Well, let's look what happened to Miss Akinsanya. Now, she is a Nigerian lady, the mother of a British child whose father has done a bunk. And she was recognized as a Zambrano carer, but she lost her job, and therefore she needed recourse to public funds. But people with derivative rights have very restricted access to public funds. The alternative was to apply under Appendix FM as the parent of a British or settled child, because it can be done that way. That's an alternative. Of course, you would normally have to pay the application fee and the health surcharge unless you get a fee waiver. Now, Miss Akinsanya did get a fee waiver, so she duly went on the 10-year route to settlement under Appendix FM as a parent. But after a further 5 years, she realized that she was now, if she was a Zambrano carer, eligible for settled status, having done 5 continuous years. But when she applied, she was told, well, hang on, you're not a Zambrano carer. You can't be a Zambrano carer and have leave to remain. So the application was refused. Now, the application, or rather a JR application, came before the administrative court, before Mr. Justice Mostyn, and he pointed out that the EEA regulations themselves define who cannot be a Zambrano carer. You can't be if you are an exempt person. So if you look down more towards the bottom of page 13, you'll see that an exempt person under Regulation 16 is someone who already has a right to reside, whether under the EEA regulations or because he has a right of abode, or is exempt from immigration control, or, and this is the crucial bit, has indefinite leave to remain in the UK. Now, Miss Akinsanya did have limited leave under Appendix FM, but not indefinite leave. And Mr. Justice Mostyn held that a Zambrano right is not extinguished by the existence of a concurrent limited leave to remain. Well, the Court of Appeal agreed. And so it's now possible for people like Miss Akinsanya, and there are quite a few of them, who've gone down the route of Appendix FM in order to be able to have recourse to public funds, but now can switch to the settlement scheme without having to pay all the onerous application fees and immigration health surcharge that they would have to do under Appendix FM. Just to finish off very briefly, we've now got a little more clarification on the difference between a sham marriage and a marriage of convenience. Now, a marriage of convenience is defined in Regulation 2 of the 2016 regulations, and actually it only applies to European cases. It has to be where the purpose of the marriage was circumventing the immigration laws. Now, a sham marriage is under the Immigration and Asylum Act 1999. It's not for European cases, it's for people marrying British citizens. And the purpose of the marriage would be to avoid the effect of UK immigration law, which is more or less the same as a marriage of convenience under the EEA regulations, but also there is no genuine relationship between the parties. Now, that is not in the EEA regulations, so it's possible under the regulations to have a genuine relationship with a partner, but to have undergone a marriage of convenience to gain an immigration advantage. And the test for that was set down by the Supreme Court in Sadowska. That's in the final paragraph. And it's the predominant purpose test. Well, if there had been time enough, I would have regaled you with some anecdotes about the primary purpose test, which I'm old enough to remember and took part in quite a few appeals against refusals back in the good old days of the 1990s, but alas, it's time for lunch, folks, so you can breathe a sigh of relief. Now, I think if we can come back at 1:45, that'll give us three quarters of an hour for lunch. And any questions that you've got, please put them in the chat box and we'll deal with them after we've heard from Nishan and his talk on the immigration rules. So we'll see you later, folks. Bye-bye. And that you got something to eat to keep you going. And well, I gave you an extra 5 minutes for lunch. And here we are about to start the second half of the proceedings with a welcome return of Nishan Paramjorthy. And he's going to be telling us about the new immigration rules which have come into force. Well, in fact, some of them, many of them, just today. So, Nishan, good to see you again. And it'll be the usual situation where you give your talk, and we're actually going to have a panel discussion just after your talk.
Yes.
So any questions that people have for you, they can tap them into the chat box, and then we'll be discussing them in the panel afterwards.
Thank you, Richard.
Over to you. Thank you.
Thank you. Thank you very much indeed. And thank you for indulging me today. I'm in your hometown, as it were, of the Upper Tribunal, where I am at the moment. And I'm here dealing with the changes to the immigration rules. Now, as always with me, my tech ability isn't always fantastic, but I put together a spreadsheet, a PowerPoint presentation with the assistance of my mini pupil to really give a brief flavour and an overview of both the government's intentions in relation to the changes to the rules, what those changes really mean, and then thereafter my own take on the changes. As you know, I'm a little outspoken about them. In essence, last year we heard murmurings from our very learned Home Secretary about the changes that she wanted to bring into place. Every time something seems to go wrong at number 10, you get a speech or some rhetoric about how the government are going to be tough on immigration and asylum, but particularly asylum. So what we've got here is some changes that really are coming into place today. The ambit of those rules and what they're supposed to achieve, and you'll forgive me because I'm looking at two screens, are to impose quite strict sanctions for those who enter illegally, but then also to draw distinctions between what the Home Office term innocent citizens fleeing problems from around the world. Afghanistan is a very relevant context of what we need to look at with regards to how those rules affect Afghan nationals, for example. Now, the Home Office has created what they call a new plan for immigration, a document that's going to specifically engage with those who claim asylum and those who've entered the country illegally. Now, you might remember some years ago, we had the very useful case of Ademi, which talked about country shopping, and that you must pick and you must claim asylum at the first country that is signatory to the Refugee/Geneva Convention. And in particular, Ademi introduced that issue. Richard will remember this case quite some years ago. Then also we had the Dublin Convention when it was active. As you know now, it's no longer in place. And you'd get cases certified on the premise that the European country that the person had travelled through was responsible for determining claims, etc. But now there are certain benefits, the Home Office tell you, in respect of safe and legal groups. So the Home Office are reinforcing the fact that there will possibly be indefinite leave to remain for resettled refugees upon arrival, or 5 years temporary residence, which leads to ILR. You might think, what's the difference? In that particular instance, not much. Once a person's been granted limited leave to remain as a refugee for 5 years, they then need to apply for settlement via Form Set P. And generally that should be a business-like application where you fill in the form. The form, interestingly, doesn't invite you to attach your previous determination or the circumstances giving rise to your grant of refugee status, but I strongly recommend that you do that. Also, there's been a change to family reunion rules that include unmarried dependent children who are under the age of 21. Now, this is a very interesting issue because at present I have an entry clearance refusal. And the entry clearance refusal is simply because the child is over 18. But my time-old argument has always been, in family refugee reunion cases, I need to demonstrate that the child hasn't established an independent family unit. So that was always my angle with this. But if this specific rule does go into a little more depth and stress that the rules are now going to be a little more indulgent with unmarried dependent children, then I welcome it. The next thing the Home Office is also thinking about is reinstating resettlement schemes. The Home Office haven't really been clear about that. Now, this is what they were talking about when, if you remember, Syrian nationals, and I'm not sure if it's still the case now, but I think it may be, Syrian nationals, when they were coming into the UK, were given some form of discretionary leave. And then under further scrutiny, they were given 5 years refugee status of short or leave to remain on humanitarian protection grounds. The reason that the Home Office are making murmurings about that is that they were internationally criticised by Amnesty International for not doing enough for Afghan nationals. And in particular, Afghan nationals who had difficulty with trying to process claims to come into the UK. You'll see the very sad cases of people at Kabul airport who couldn't get in before the deadline. It's unclear as to what's happened to them. And many of them have gone to, if I can call it, third countries in loose terms. But then there's a tension now. So on the one hand, the Home Office are not particularly keen about those coming in from other countries and want to penalise them for it. And in particular, Afghan nationals to that end. How is their resettlement scheme going to really work? But that means essentially that so for example, Syrian nationals, Afghan nationals who've ended up in Turkey aren't particularly keen on having refugees there. What would be the Home Office's position when they come into the UK? I mean, that's my rhetorical point to think about. So there is, first and foremost, a lack of clarity with the intention of what the Home Office want to achieve and the applicability. Now, looking at the consequences for those who enter illegally, under the new rules that have come out today, those who come to the UK illegally and who have travelled in the UK, after travelling through a safe third country, such as Greece, are going to be given fewer rights than before because of such actions. There's one main problem with this. If you've come through Greece, and let's say, for example, you have been kept in Greece for whatever space of time, Greece pretty much do not screen those seeking protection in any meaningful way. And one of my very close former colleagues, Ms. Fisas, who's in another chambers altogether, specifically challenged whether Greece was a safe country in respect of third country applications. So that still remains a live issue for me. And the motivation, the rationale for the Home Office wanting to impose sanctions for those who enter illegally has been one on some humanitarian basis to stop those crossing over by boat from effectively dying and drowning. We've seen the very sad cases in the last 6 months. And I understand the need for protecting those who enter in that way. But the Home Office say this. They say that there's been an observation in the UK court system that there have been repeated criminal claims and appeals by foreigners who have not attained the right to be in the UK. I'm not entirely sure what that means. This may result in a wastage of time and even resources, which in turn results in delays of hearings in the courts. The new immigration rules in the UK for illegal immigrants have been introduced with the aims of achieving the objectives of stopping these sort of repeat applications. Well, that flies in the face of the new matter provision that came out with the advent of Section 85(1) of the 2002 Act. Because in simple terms, those who are making claims under the Human Rights Act or asylum claims often have changes in their circumstances, and those are organic changes. They consequentially result in updated applications going to the Home Office, and that consequentially invites a response from the Home Office that often attracts a right of appeal. I think it was Priti Patel's comment to say that she sees too many repetitious, fictitious, repeated claims with a design to frustrate removal. But she's demonstrably failed to particularize or provide us with any meaningful statistics to tell us how and when and in what context that happens. Now, the objectives of this tougher new regime is to alter and deal with those living in the UK without the legal right to be there. I think this is the hostile environment that the immigration rules and the Home Office provide for, because we know at the moment that those with no permission to be here generally cannot open a bank account, cannot register with a GP, cannot afford themselves or really of any support from the state, and that's with a view to removing them. That's why the new immigration rules that will kick off today apparently will engage with the ease in which illegal immigrants can be removed. And apparently this is to ensure efficiency, fairness, by guaranteeing that people with genuine needs are given protection and support. We get lots of bold statements. Apparently this will make big changes. It will put an end to people who illegally enter the UK. Now, the United Kingdom is apparently going to now be engaged with dealing with and distinguishing those who are innocent citizens from around the world. And in particular, the rhetoric is this, that in doing so, the Home Office will reunite families by welcoming relatives through refugee family reunion. But we still do have the refugee family reunion policy, so I'm not sure what's new about that at all. Introducing a pathway for visitors from overseas and resettling those who are misplaced. These two, a big number applies to children. I have no idea what the context of that is. Resettling those who are misplaced. I assume that means overseas, but the Home Office haven't made that clear. And apparently Global Britain will, and the UK will maintain clear routes for all refugees who might be in need and will maintain their freedom to contribute to UK society when they arrive. Well, that clearly can't be the case at the moment, because refugees are not permitted to study, are not permitted to work technically. And I'll come to that in a moment. So in order to achieve a safe and legal way to enter the UK, illegal immigrants will apparently, and those claiming protection now rather, will have a slightly greater benefit. Now, a lot of the practitioners who do asylum and immigration may have seen lots of YouTube links sent to them. And those YouTube links seem to suggest that one, the Home Office are going to announce an amnesty, or two, are going to announce a greater understanding of the need for asylum seekers to work. We all might remember last year that there was a judgment, I think it was in the High Court, concerning a lady who had been found to be a victim of trafficking, and for her need to work as a cleaner in order to sustain herself. Now, the Home Office didn't quite expect that judgment to be so persuasively against them, but it may have provoked a different view. So the Home Office potentially want to do the following: grant refugees who have resettled permission to remain in the UK, permission to work, to allow and support refugees to obtain employment in the UK by introducing a system where they can access and apply for work. We haven't been told of the framework for that. You all might be aware that at the moment the Home Office do grant permission to work in what's known as the shortage occupation list for those who essentially have been waiting for a decision in their case for 12 months or more, or have got fresh claims pending for 12 months or more. And clients have often colloquially been asking me to apply for a work permit, in other words, permission to work. So I don't know whether the Home Office are really just echoing the same point that you can apply for permission to work if you've been waiting for a decision for 12 months or more, or whether what we hear in the news and on the internet is that those who claim asylum may be actually given permission to work, may receive asylum registrations cards that actually allow them to work. So we'll wait with bated breath. And apparently the new immigration rules will ensure that the resettlement program is active and will respond to the needs of refugees, allowing them to settle more quickly. Just to draw an analogy, Australia has quite a tough immigration system, but they only have a one-tier appeal. But what's interesting is if you succeed before an immigration judge in Australia, you're pretty much, if you're in detention or not, you're pretty much given accommodation, provided with funds with which you must undertake an English course and you're sent to an area that has employment, and you're given permission to work, and you're started on that sort of track. Now, I know that the UK government have found the Home Office, the Australian immigration rules attractive, because that was the whole purpose of the July 2012 points-based system. But what the UK didn't quite appreciate is that the population of Australia is about 30 million, or however much it was at the time. We've got about that same population in London. So quite how they thought it was going to be applicable to those numbers is beyond me. Now, traveling in and out of the UK has been limited by the new immigration rules for illegal immigrants by temporarily staying for 6 months. So I'm not entirely sure what that means either. Traveling in and out of the UK has been limited by the new immigration rules for illegal immigrants by temporarily staying for 6 months. No idea what it means. I think they're going to take a very dim view of those who come in and overstay, essentially, and who come in as visitors. And the immigration rules, the echoing of the rules for visitors is that they're not allowed to work in the UK unless they come into a specific permitted category. I'd like to take a few minutes to talk to you all about a problem that I've been facing with many of my clients who applied to extend their leave to remain. Let's just take a hypothetical example of a client who has got leave to remain and is applying for further leave to remain using a prescribed form. Let's choose FLRFP. So the client comes in, I complete the form online, and we do the biometric and we upload the necessary documents. It's done. My client's employer then repeatedly emails my client asking for a copy of her new visa. My client tries to point out the impact of 3C of the 1971 Act and that her right to work continues. I then make it clear via my client to her employer, do an employment verification check. But some of them have been coming back with negative responses, and I'm not sure why. So in order to try and help clients in that position, the Home Office have devised a view and prove link on their website, which generates a share code. And that share code apparently is designed to give clarity to those who are applying for an extension of their leave to remain in the UK. And that share code basically allows your employer and any relevant parties to establish your immigration status and establish your right to work. But I found lots of difficulties with the use of those share codes. They don't work particularly well. So in conclusion, what the immigration rules encourage, or apparently are going to encourage people to do, is to get access to their own files, to make changes and updates when required, to update email addresses, any changes of name and data. And you're encouraged to effectively use that system in order to do so. So if you need to access your immigration status, the new immigration rules allow you to do so through the UKVI Resolution Centre. It allows you to log into your account, recover it, update your immigration status, and then share that status using a share code. I'd like to give you a summary and an overview of how the rules take place. So they're taking place today. That's the implementation date. If an application for entry clearance or permission to enter or permission to stay has been made before the 15th of February 2022, such applications will be decided in accordance with the rules as they were on the 14th of February 2022. Guidance relating to these rules will be updated and placed on the website, on the gov.uk website today, when these changes effectively take place. A summary of some of the changes are that, except in prescribed cases, EEA nationals will no longer be allowed to use their valid national identity card for entry to the UK. They will need to use a passport, and a valid one. launch of the new international sportspersons route, which replaces existing routes for professional sports people, requires endorsement, sponsorship, meeting financial requirements, and in some cases meeting the English language requirement. That's a new element of that specific rule, the English language requirement. And then you have the global talent route for talented and promising individuals in certain fields. And it will see the changes for the endorsement element and the prestigious prizes element, which bypasses the endorsement requirement that previously existed. The old working holiday visa, or the youth mobility visa scheme, is being expanded in January, well, was expanded in January 2022, to allow citizens of India and Iceland between the ages of 18 to 30 to apply and live in the UK, live and work in the UK even, for up to 2 years without sponsorship, with additional requirements for Indian citizens, including holding an undergraduate degree or having a minimum of 3 years work experience in a role equivalent to the approved list of jobs. Now, that's quite an interesting opening between India and the UK, and it's a result of a bilateral agreement signed between both of them to try and attract young specific talent to come here to the UK. Now, going back to Afghanistan for a moment, changes are being made to the existing rules relating to Afghan citizens under the Afghan Relocation and Assistance Policy. The Home Office have published the Afghan Resettlement and Immigration Policy Statement and some promotional material called Next Steps in the UK, Immigration Information for People Evacuated from Afghanistan. Now, this doesn't form part of the immigration rules, but is something that the Home Office are pushing with vigour. And with respect of all Afghan claims that anyone has at the moment, and I was very recently here again in the upper tribunal at the end of last year, please make detailed written submissions to the Home Office, even if you have an extant appeal, to see whether your client falls within the categories that clearly are at risk. Well, there's no removal to Afghanistan at the moment, as we know, and the problems there are continuing and escalating. Now, other items to note. The current traffic light system for travellers to the UK changed on the 4th of October 2021. The temporary changes to the right to work checks that were due to end on the 31st of August 2021 have now been deferred to the 5th of April 22. And the Confederation of British Industry called upon the immigration rules to be relaxed because of the huge shortage of labour, for example, in hospitality, food processing and logistics, which is why actually the government, I think, are looking at trying to give permission to work to those who've claimed asylum. The government's also announced temporary visas for up to 5,000 HGV drivers and up to 5,500 temporary visas for poultry workers, and that's something that they're still trying to extend to fill the gap in. I'd like to talk a bit about the skilled worker visa. It allows you to come to work in the UK to do an eligible job with an approved employer. This is the replacement of the old Tier 2 general worker visa. Knowledge of English must be important. You must be able to read, write, and understand English. You've got to be able to work for a UK employer who's been approved by the Home Office. You still require a certificate of sponsorship with a sponsor license number, a valid passport. You need to do a job that has an eligible occupation code. The job title and annual salary must be commensurate with that code, and you must be paid a minimum salary, and that depends upon the job that you're doing. General scope of documents you need for the skilled worker visa is evidence that you've got enough personal savings to support yourself, proof of your relationship with your partner or children if they're applying with you, a TB test result to demonstrate that you don't have it, criminal record certificate if you're working in certain jobs, a valid ATAS certificate for a job that involves researching a sensitive subject at PhD level or higher, and you need to have a qualification from outside the UK. You need also to demonstrate that you have a certified translation of any criminal record certificate from the country you're applying from, specifically if you're really wanting to come here to work in education, healthcare, therapy, or social services. And you require a certificate of every country you've stayed in since you turned 18, going over 10 years. That's quite an onerous request. I'm not sure how realistic that is. I've put in a flavour in the new handout, which should work its way to you with thanks to Vasant, the sort of salaries and the sort of codes that you need to meet for that. With a skilled worker visa, you can stay for up to 5 years, and you can extend or update your visa when it expires if you change jobs or employer. Now, if you want to stay in the UK longer, you can extend it as many times as you like, as long as you meet the eligibility requirements. But what is useful is that after 5 years, you might be able to apply to settle for indefinite leave to remain. So that's an overview of the rules. That's my take on an overview of the element parts of the rules. But what I'd like to also talk to you about is something that's not included in my handout. I've been dealing with lots of criminal deportation cases, but specifically bail applications. And I think many of my colleagues are having difficulties with the new change, if you like, to the rules that came out in August 2021, which is that if your applicant has a deportation order, in particular, you are now to ensure the tribunal is there to ensure that there is a release on electronic monitoring. We just call it a tag, shall we? Now, the difficulty with that is often people have licenses. Often there are license requirements. Now, all of these requirements mean that addresses need to be checked before a person's released on bail. But the practicality of this is that often the offender manager has very little time or incentive to liaise with probation. COVID lockdown measures in the prisons have resulted in addresses not being checked. And there's been differing views from experienced first-year tribunal judges as what to do. The Home Office party line is generally, well, if you release a person without having checked the address, it's a breach of license, and that we will only agree to a release on bail in principle, and there will need to be a review in 28 days. And that generally has been going on. But there's a point that I raised with the tribunal, which is this: the administration and the policing of the license is really down to the offender manager and probation. It is not for the immigration tribunal or for the Home Office to ensure that compliance. If a person is going to be released on electronic monitoring, we should apply as advocates, as representatives of applicants, for the person to be released on bail exactly in that manner, a release on bail. And then it is for the offender manager and for probation to establish that the address is fine in that 72-hour glorious window that's given for the Home Office to make sure that the monitoring takes place. If it's not done, it's simply disproportionate, in my view, and unlawful for somebody to remain in mainstream prison any longer, or detention any longer than they need to be. And it is not the tribunal's fault, nor have the tribunal acted in breach of license by releasing someone on probation, on bail rather, because it is essentially for the offender manager and probation then to deal with. If they're overwhelmed and they find it difficult to keep up to date with their obligations, then that cannot reasonably justify ongoing detention of applicants. So I would invite everyone to be quite assertive with the fact that you see a bail summary repeatedly saying the address hasn't been approved, we don't agree to a release on bail. And we should try to resile from merely throwing in the towel and agreeing to bail in principle. So I think the changes to the rules that I mentioned earlier and the changes to the rules in relation to bail applications are all particularly relevant at the moment, because we'll see more and more of this happening. As with all of my specific talks that I do, I've come to a close with everything that I've said, and I often go a little too fast, but even by my standards, 35 to 40 minutes is quite good. So I'll just go over to Richard, if he's there, and take his advice as to really where we go from here. Richard, if you're there.
Yes, I am indeed still here, Nishan. I wouldn't want to miss your talk. And you actually did very well time-wise. You've actually finished a little before 2:20.
Right.
So we're actually ahead of our timetable, but that's great. So we're going to have a panel discussion. But before we start, I've been asked by Wasanta Tenakun, our generous host, to mention, which I forgot to do before lunch, that there will be certificates of attendance sent out to all the attendees by next Monday. So you will get your confirmation of attendance for CPD points. Now, I think we'll be joined by Sarah for a panel discussion, and there will be questions that have cropped up in the chat box, which we can discuss, and indeed other questions which people might like to bring up during this 20-minute session. And then we will have a tea break. So I wonder if Sarah, there she is. So Sarah, you're all set for our panel discussion. I'd just like to start the ball rolling with something which I think is directed to me, and it was a question about being refused naturalization on bad character grounds. And it concerns somebody who made an application in 2018 and was refused because he was said to have used a proxy to take the English language test set by ETS. And the question was, how long would that person have to wait before he can make an application for naturalization? I think the usual time span is 10 years from when the thing occurred which is causing your application to be refused. So for example, if you've been in the UK unlawfully, you have to wait for 10 years after you first get leave to remain. So you've had a period of overstaying. You then get leave to remain, which becomes indefinite leave. But if when you apply for naturalization, you last had a period of unlawful residence within 10 years of the date of application, they won't grant it. You have to wait a full 10 years. I think, therefore, the answer to the question about cheating in an English language test, I think they would date the, well, would it be the date of the taking the test fraudulently, or I suppose it would be the date when you use the result of that test to apply for leave to remain and get it. I think that would be the date that has to be more than 10 years previously. Do my colleagues have any suggestions about that? I think that must be the answer.
I think that is the answer, to be fair. I don't think there's anything more to it than that.
Yeah, and they're just getting really strict on the anything in the 10-year period.
Completely.
Right. Okay, well, I guess that's the answer to the query. Now, there have also been questions for Sarah, and I don't know if you've got any yet, Nishan?
I should really look, shouldn't I? Sorry.
Well, yeah, there was one. Should we let Nishan go first?
Yes, I better quickly read it. I'll read it
Sure
out.
thing.
I'm not sure if everyone can see it, but I've got a client from Afghanistan. His entry clearance as a British spouse was refused, submitted her appeal. She's managed to come to UK. Can you appeal or submit a new application? Should I type the answer, or can I just say what I think?
Oh, you can, yeah, say it.
Well, the first question I need to find out is, how did she come in, first and foremost? Clearly, the entry clearance appeal is probably, the appeal is redundant, because one way or another, she's within the UK. Is it because she's made another application for entry clearance, in which case just withdraw it? I'd like to know probably a little bit more on how she's got here. And that's not my cop-out answer, but if she's arrived here legally, well, then I think you'll probably still have to withdraw, because the remedy that you're asking for, you've somehow achieved, no matter by which means that you've basically arrived at that. So my view would be that you would withdraw your entry clearance appeal nonetheless. And clearly she's not going to be going anywhere for a very long while. And if she's entered illegally, regularize her stay, make an application for leave immediately. Or if it's an asylum claim, go down to the ASU and first of all naturally call them and make a claim for protection. So it's, I think either way you withdraw the application. I don't know what Sarah thinks. I think that must be the right way.
Yeah, I think that's right, in the sense that even if, well, I think, yeah, there's provisions to treat the appeal as being withdrawn if effectively you've come in. But that was probably in the context of being granted leave to come in. It's this situation, obviously, with Afghanistan brings in new variants of that. Yeah. But yeah, I would clarify that and then make reps, or, you know, make an application to the Secretary of State as soon as possible. Yeah. I think that, was there anything else for Nishan? Should we stay with Nishan as long as possible?
Oh, thank you so much, Sarah. It's very kind of you.
But I think, yeah, I had a few, so I'm happy to go if there are no others. Yeah.
I've got something before I forget, if I could just get it in. There's a question about the countries which may or may not give permission for live evidence to be given by video link. And the questioner says, I understand there is a list of countries where such permission is not required. Now, I don't know about a list of countries. Certainly, the Foreign Office can tell you if the country that you're interested in has indicated within the last 5 years that it doesn't approve of live evidence being given from its territory. So I guess there is a list then kept at the Foreign Office, and you just have to ask them if country X is on that list. If they don't have anything going back, if you want to find out anything going back beyond 5 years, I think you have to make an inquiry and pay a consular fee. But, yeah. Anyway, that was the question. That
yeah, and I think that's right, Richard. And also there is some sort of understanding by the FCO countries that they prefer, if you like, where they don't have any issues with evidence arising from the case of Nare. So I think, but there's also this vague position where if there's any, if you like, confusion or lack of clarity about it, you are to apply for permission anyway, which is, I think, a little unhelpful sometimes.
Yeah, that's what I've heard in terms of the message seems to be that judges need to have, in order for, like, it's not enough for the parties not to be bothered by it or for the parties to have agreed a position on it. I think what I've heard is that the tribunal for itself needs to be satisfied of it. So it's going to be raised by the tribunal of its own initiative if it's not otherwise. And then the second, that they need positive confirmation of it. So it's either positive confirmation that's arisen more recently through this process of the reported decision, or, as you say, email confirmation. I don't know, I think we've yet to see the resolution of this. Yeah.
Looks like it'll be a long time before we commonly have entry clearance appeals with the appellant taking part.
Yeah, and what I don't know, I mean, I don't know if there's solicitors and practitioners in other areas of law, but it doesn't, I don't know, it doesn't seem, I haven't heard of this issue being a problem in other jurisdictions. I don't know if it's because in other jurisdictions they maybe have the money to fly over their witnesses, and maybe that doesn't happen obviously in ours, but I don't know. Yeah. Sorry, rather unhelpful.
Judge in the family division said that he commonly conducts video link hearings with parents or spouses overseas, and there's never been a problem.
Yeah, so that was my understanding as well. So I hadn't heard of anybody saying, well, the family courts said this or that. So it's a bit, yeah, I don't know the answers as to why this is all going in this jurisdiction. But
I just want to check, can you all see me? I've managed to do something very bizarre with my screen, so I can just see Sarah at the moment, but I'm just hoping you can all see me.
I can see you.
Yeah, no, you haven't moved, sadly for us.
No idea how I've done that, but there we are.
It happened to me earlier, and I think I clicked hide self view, maybe that.
All right, okay, if I disappear for any reason I shall come back in, but don't worry.
Richard, was there anything else on your side?
No, I don't think so.
All right, I'll fire off my, I think I had 3 EA ones. The first was from Mohammed Enamul Haq, I think, on the chat. So I'm just going to quickly repeat, and I think it was echoed by someone else, Junaid, on extended family member appeals that were made before, that were lodged before the end of the transition period, whether the applications were lodged before that and then the appeals continued, or whether the appeals themselves were lodged, doesn't really matter. But basically they took some time to be resolved. We touched on that in the presentation, and they still have not been implemented. And I think across the board, we've all had cases, I think, where that has been the case. I've got one of mine, I think that was July of last year, I think, has still not been implemented. I would say, and so was asked for my view on that, I would say, depending on the timescales that have elapsed in your cases, consider lodging, a firm letter to the post, but keep a tight time frame on it. If there's still no engagement, no response, then escalate it to pre-action protocol letter on delay, failure to implement, and allowed appeal. And you may find that that triggers things. If it still doesn't, then I think, again, legitimately, you would have a judicial review claim that's not likely to then settle, even maybe before a decision on the papers, because they have confirmed the position in law that they are going to be provided for through this concession. So I think it's quite straightforward grounds, quite straightforward arguments. Again, it's dependent on the timescales that you are dealing with. How long a delay has it been? And you may have some case where it's longer than others, but on the long ones, I think we've come to the time where it's not reasonable. So I would say go for it. The second query was from Tajamal Butt concerning a Norwegian citizen who had been resident in the UK between 2004 and 2012, again in the chat box, so not perhaps easily located for those wanting to see the question. But this Norwegian citizen had left the UK in 2012 and didn't come back until, I think, June of last year. So could they effectively gain their residence rights again? So one advantage of having the lunch break in between is that I was able to check, because there are provisions for a historical period of 5 years residence to count. So a person can rely on 5 years historical residence as a European citizen, as long as that 5-year period happened and was completed before 31st of December 2020. But there is several provisos, but one that would be relevant in this case, which is that you can't have a period of more than 5 consecutive years that has elapsed since. So if they left the UK they can't have left for more than 5 years in order to rely on it. So had this person returned in 2017 or thereabouts, they could have claimed it. They would have then had the other period of 5 years, I suppose. But, you know, had the gap not been as long, they could have claimed settled status on that basis. But because it's been more than 5 years, it would seem, as far as I could see, that they can't rely on that previous period. So query whether they did return, you know, even for a short visit or whatever, and whether you could make that work, and get round the 5 year gap, the more than 5 year gap. But otherwise it doesn't look great, and that person would potentially need to look to other avenues now. And I think that was it from me, maybe. Let's see, there was a question, actually, sorry, in the Q&A box, there was a question from Sirajam Munira that I wasn't clear on, so I asked for clarification, but I don't think it's been clarified, whether the person was asking about British citizens who are returning with their dependents to the UK, having exercised rights in another member state. So if we get clarification during the session, then we can look at that. And then, let me see. Oh yeah, there's a question from Thurindu. A family member joining EU national who was in the UK before the 31st of December is granted a 3-month entry clearance visa. Once they enter, they are expected to apply under PSS. If they miss the deadline, can they still apply for PSS settled status out of time? My view is yes. Same guidance applies. Reasonable grounds. So if we look at the withdrawal agreement is where I would go to on this, I think. And it's under 18, sorry, I still had it open from earlier. 18, yeah, so 18 little 1b provides for the deadline in country, which is obviously not the relevant one here. And then it says for persons who have the right to commence residence after the end of the transition period in the host state, the deadline for submitting the application shall be 3 months after their arrival, or the expiry of the deadline referred to referred to earlier on, whichever is later. And then 18(1)d, where the deadline for submitting the application referred to, that I've just referred to, is not respected, the competent authority shall assess all the circumstances and reasons for not respecting the deadline, and shall allow those persons to submit an application within a reasonable further period of time if there are reasonable grounds for the failure to respect the deadline. Okay, so reasonable grounds, then you submit it within a reasonable further period, and you give all the reasons as to why you're late. So I think that answers that. Whether obviously it's an issue, whether it's granted or not, whether the reasonable grounds are accepted, obviously then depends on the case. Okay, I think back over to you, Richard.
Yes, I'm just looking at a couple more questions in the Q&A box. There's one that says...
Richard, I'll just let you know that I am here. You just can't see me for the moment.
Oh, right. Thank you. Yeah, this is asking about indefinite leave on the basis of the private life tenure route, which opens applications in June this year, whether the new rules impact on this. Well, indefinite leave to remain on the basis of private life, tenure route. Well, I mean, that's been going for a long time, hasn't it? If you have been granted leave under Appendix ADE, sorry, paragraph 276 ADE, you get on a 10-year route to settlement on the basis of private life. I don't think the new rules say anything about that. And I don't think that you can get indefinite leave sooner than 10 years, unless you're one of those people between the ages of 18 and 25.
Yeah.
And yes, if you fall into that cohort, you can
Yes.
get indefinite leave after 5 years.
Yeah.
So yes, there has been a change.
Yeah.
I think
a significant change, isn't it, compared to
It's
before?
great. Yeah. Yeah, all
think that
led
was-
by We Belong, I think, a group called We Belong.
yes, that was a bit before the current batch of changes that Nishan was talking about.
Yeah.
Yes. And then there's a question about whether a period of temporary admission, which then resulted in a grant of limited leave to remain, whether somebody can apply for indefinite leave even if the person has not had a complete 10 years on this route. Oh, so whether a period of temporary admission can be included in the 10 years. Temporary admission before limited leave to remain was granted. I think you have to have actual leave to remain, don't you, rather than, oh, wait a bit, temporary admission that seamlessly transmutes into leave to remain. Maybe it can be included.
Yeah, I'm not sure about the June 2022 route, to be honest. I haven't updated myself on that. But from the long residence rules, the 10 years, TA can be counted as lawful as long as leave was then granted at the other end. So it would depend on, the chronology of it. But how that impacts into the June 22, I don't know, maybe Nishan.
I think TA can't be used to mop up gaps where, if you like, there was no leave, or if the TA was all part of waiting for leave to be granted, and it was then established that leave should have been granted some time ago, then you could rely upon it. But often, I think many clients often misunderstand every time the Home Office talk about 10 years residence, that if they've been here for 10 years with different forms of TA and they've been without leave, that it entitles them to permanent residence or indefinite leave to remain after 10 years. A classic example is someone waiting on a fresh claim who's on TA and says, I've been speaking to the Home Office, I've been clocking with them on a weekly basis for God knows how long, and it's taken years for my claim to come to be heard. I think even then, that sort of TA wouldn't transmute into 10 years lawful residence. I think it's fairly strict on that.
What's this about June 2022? What's supposed to be happening then?
What's supposed to be happening is a greater understanding by the Home Office for those who don't have, if you like, adverse suitability issues such as criminality, or perhaps who've been in the UK for some time waiting for decisions. I don't think they're ever going to say that TA would transmute into lawful leave, but I think it's going to be the Home Office intend to look at things in a slightly more favourable manner. Whether it's actually implemented, I don't know, because the June 2020, Sarah will tell you that the intentions are all there apparently, and there are talks loosely of an amnesty, but no one's particularized it at all yet.
Well, and it's more of the same in terms of how opaque it is, in the sense that, and Nishan touched on the Afghan resettlement scheme. I mean, it's and those that are resettled, to use the Home Office term, get ILR. I mean, all those that came in August 2021 still haven't seen ILR, as far as I'm aware.
Yeah, they're all being tactically parked up in case something happens really with the Taliban in Afghanistan. I think everyone's being tactically parked up.
Yeah.
Well, it's interesting that.
Sorry, Richard.
Oh, interesting to hear that an amnesty is being mooted again. There have been rumours of that, which never came to anything.
I can't see the Secretary of State. bringing one in.
Not Priti Patel, that's for sure.
Yeah.
There would have to be a
Yes.
shake-up for for that to happen. Oh, I've spotted something at the bottom of the Q&A. I mean, British adult carer or dependent application under the deadline of the 30th of June 2021.
Okay, so that relates to that question.
Zambrano. Is that Zambrano?
Yeah. Okay,
Adult carer.
Zambrano. Yeah, that would make sense.
Yes.
Okay, yeah. Sorry, then that makes sense. If Mr. Munira, I think it's maybe a Mr. Not sure, Sirajam. So let me go back to the initial question that is in the other box. Yeah, I mean, I haven't looked at the late applications in the context of Zambrano type carers, but I suspect they're in the same boat in terms of being under the same test of showing reasonable grounds, because the reasonable grounds comes from the withdrawal agreement, as we just saw, which covers, you know, they're supposed to cover this transition period and the rights of all those that wish to establish rights arising from pre-Brexit. So I suspect it's the same, but Zambrano's a bit of a special case in that we've got the Akinsaya litigation. Did you touch on it, Richard, in your talk? I think I heard you.
I did, yes. Yeah, it's maybe not everybody realizes that the two things are complementary. If you are the third country national carer of a British child, you're the primary carer. You can either go or you could either go the Zambrano route when that was open for you to apply, or you could go down the parent of a child under Appendix FM, that route. And of course, it's much cheaper to do it under the Zambrano route.
Yeah. Yeah, and so that's still up for grabs with this litigation. So I think just bear that in mind, Sirajam. But I would say late applications, yeah, reasonable grounds, work it in and take it from there.
No, have we got anything else at the moment? Oh, here's one. British nationality matter. Client was granted refugee status, having claimed asylum around a year after arrival in the UK. Would she be eligible for British nationality after completion of 10 years? Or can she try earlier too? Maybe that means including the year after arriving in the UK before she was recognized as a refugee. So would the 10-year period start when she gets leave to remain as a refugee, or when she actually arrives in the UK?
I mean, sorry, Richard, it's me, Nishan here. So if I've understood the question is that let's assume hypothetically the applicant arrived a year ago, but now has 5 years limited leave to remain as a refugee. The applicant will then, after those 5 years, we wouldn't be able to use up the year before. After those 5 years, on the expiration of their refugee leave to remain, have to apply for settlement via Form Set P. And then a year after that will be eligible to apply for nationality. So it's not 10 years isn't the relevant time period. It's 5 years limited leave to remain. Then you apply for indefinite leave to remain, and then a year after that, you then apply for nationality, if I can put it in those terms. So it's normally about 7 years.
Yeah,
not
right.
10.
So it's nothing to do with the 10-year route to settlement at all, because as you say, you get it after 5 years. You get indefinite leave after 5 years as a refugee. Mm-hmm. Yes, but it would be the 5 years of leave, not when you first arrived in the UK, but when you got your grant of leave.
Absolutely. Yeah, we wouldn't be able to use up that year as as having said, well, I should have been granted refugee status that time. I mean, there would have been interviews, perhaps, and a screening and full asylum interview in that space of time, I'm assuming. It's unlikely that there would have been an appeal if the applicant was granted asylum a year after having entered, because that would assume that things move ridiculously quickly, and we know that's things are challenging with time spans at the moment.
Oh, here's another question. Somebody living in the UK for over 15 years, family breakdown, can he apply for leave to remain under human rights? Well, he can apply, but of course it's well short of 20 years. So if all he's got is private life, the application is likely to be refused. And it would carry a right of appeal, but those are pretty hard to win as well. If all you've got is private life, you don't have a British partner or child. Yeah, I think we see a lot of attempts to apply for leave to remain by overstayers who haven't clocked up 20 years. And really they're down to arguing that they can't reintegrate in their own country. They've lost touch with everybody and they wouldn't be able to get a job, etc. It usually comes down to arguing that if they haven't actually lived here for 20 years.
Although, Richard, I'm completely of the same view, except something quite strange happened recently. I was representing a Sri Lankan gentleman who'd been here for 18 years. He had an extant appeal before the tribunal. It was on protection grounds, but also private life grounds. I think it was 17 and a half years. He'd become totally disenchanted with the delays and elected to file an FLRFP application on a super priority basis whilst it was pending. Now, my Article 8 decision subsumed in the protection decision from the Home Office said, you haven't hit the 20 years. Your status has always been not even precarious. You've been here unlawfully. So, no weight will be attached to it, except lo and behold, he applies for a super priority visa and then manages to obtain leave to remain on the basis of how long he's been here 24 hours later after submitting his biometric appointment, which resulted in the client saying to me, well, if what you say is correct and you've got an appeal pending, how is this the case? So I'm a little lost as to the consistency of decision making for those who've been here for 15 years or more.
Well, it pays to go for super priority if you've got the money.
800 quid apparently, Richard.
Well, money well spent if you actually get leave to remain, eh? Oh.
Yeah.
Well, I see we've actually been joined by Jamila Hassan. Hello. You've probably gathered that we're running a bit over time. This was the panel discussion. And well, panel discussions could go on for a very long time, but I guess we ought to break off now for our afternoon tea break, which was supposed to be from 20 to 3 till 10 to 3. Well, we'd better make it, let me see, it's 10 to 3 now. Better make it till 3 o'clock. It's 3 o'clock and Jamila has rejoined us, and I hope you've all had time for a cup of tea or coffee to keep you going. But Jamila will now be telling us about domestic violence applications and associated challenges. And then she'll be followed at, I think in this case, it will be 10 to 4. She'll be followed at 10 to 4 by Joseph Byrne talking about statelessness. So Jamila, without further ado, I'll let you take over. Thank you.
Thank you, Richard. Good afternoon, everyone. And I'm grateful to Sarah for filling in for me this morning. I had another matter that was quite urgent. I propose to speak to you today about domestic abuse because I think it is something that comes up quite often, both in family practice as well as immigration. And it seems to be something that is straightforward, but sometimes one can get it quite wrong if one doesn't consider all of the evidence that is required and doesn't put that evidence in the form that is required. So I propose to share a screen with you. If I propose to share my screen, and I start off by explaining what domestic abuse is. And you'll see at the bottom of the page there that I refer to the Home Office guidance for staff dated 24th of November 2021. That is an incredibly important document because it sets out what the Home Office staff will be looking at in determining applications for ILR on the basis of domestic abuse. The term of domestic abuse itself is quite new. You will be aware that previously it was domestic violence, but there has been some development in this area and a recognition that not all elements of domestic incidents involve physical violence. So abuse is intended to incorporate other forms of domestic incidents, which are set out here in this page. I've copied from the caseworking guidance, and you'll see there that it says the abuse can include but not limited to psychological, physical, sexual, financial, and emotional. On the following page, you can see that the Home Office also includes behavior that is controlling, and it says that controlling behavior is defined as a range of acts designed to make a person subordinate or independent by isolating them from sources of support. So you will be aware of many cases where individuals have brought their spouses to this country and have effectively asked them to just remain within the home, not work, not seek out any support from medical services or other agencies. Exploiting their resources and capacities for personal gain. There will be those who have to work. So there have been a couple of cases of recent that I've seen, particularly in the family court, where particularly husbands have said that in fact they were brought to this country by their spouses, and their in-laws have forced them to work and give up all their earnings. Depriving them of the means needed for independence, resistance, and escape, and regulating their everyday behavior. I'll come back more to this because this is a recognition that stems from some family court cases that we will look at later. You'll be aware under the definition of coercive behavior, and this is important. It says an act or a pattern of acts of assault, threats, humiliation, and intimidation. So it's not sufficient. It's not just one act that you will be looking at. So if there isn't one major incident that your client can point to, then perhaps it's better to sit down with them and discuss what their day-to-day living entails, what they do, what happens, in which circumstances things happen, and you'll see a pattern. And it is that pattern that is recognized as well. Whereas previously, you'd be left with perhaps somebody who gives you a narrative and you think, well, this narrative will not be accepted because I can't see one major incident of violence used or one major incident of coercion that has to be traumatic. But in fact, you can consider everything and think about it, that the judge will be looking at it in the round. And it's not just one particular act that is relevant, but a pattern of acts. It also says other abuse that is used to harm, punish, or frighten their victim. Now, in many of these cases, you'll be aware that victims say that they have been threatened or frightened by the perpetrator saying, for example, I will phone the police. The perpetrators often have their passports or their documentation and will say, well, I will phone the Home Office or I will phone the police if you don't do as I say. And then you will get into prison and you'll get into trouble because you don't have your documentation. That in itself is evidence that you can use in your statements. I've seen sometimes that people forget to include that type of evidence because they think that perhaps it doesn't amount to domestic abuse, but in fact it is. If it is intended to frighten the victim, then clearly it is domestic abuse. And indeed, as it says in the last sentence there, no distinction between physical and psychological and physical abuse when assessing applications. That is what the Home Office is supposed to do, and to not make that distinction. But in fact, sometimes you will see in most of these letters from the Home Office that they say, well, we can't see any particular evidence, and they ignore the psychological part, but that part is important and has to be included. Now, I referred earlier to the case of, and I mentioned that there is a lot of development in the family court arena, and that there is more information and assistance to tribunals in determining these cases of domestic abuse. The case of REHN is particularly important because it's a case that involved allegations of domestic abuse. It involved allegations by one parent against the other, and it was the case where the court, there were 4 appeals in this case, but one of the most important things was that the court actually went painstakingly went through a lot of the evidence and identified patterns of behavior, and the court explained that that it is important for any practitioners to consider the welfare of the children, but also to consider patterns of behavior as opposed to specific incidents, and that is what we were talking about earlier, and that these incidents have to be assessed cumulatively and not in isolation. So it's not the case where they say, well, it's what something happened in June and then nothing happened until December, and therefore it means that this was hardly, this was hardly an issue, and those 2 things are minor on their own. However, sometimes you have to say, well, actually, looking at it cumulatively, what impact did it have on the victim? I would propose that you also read the case of FNM, and in particular, that case was cited in REHN, and in that case, again, the court considered the effect of domestic abuse on victims. It considered the patterns of behavior. It considered the fact that sometimes the way that women in particular, because those were the ones that were considered the relevant facts in the case related to mothers, women in particular were systemically isolated from study and work. They were isolated from their friends and colleagues and family. And it's important to read the entire judgment because it sets out the scale and nature of coercive and controlling behavior. And you will be aware that in many cultural situations that victims might wish to leave their perpetrators, but they can't because there are cultural issues that prevent them from leaving. And it's important that if you're preparing a witness statement with an applicant, that you speak to them about what was happening around those circumstances. What was it that led to them fearing their perpetrator? And quite often it's not just the perpetrator they fear, but also the consequences as a result of consequences of what would happen if they were to leave, or what would happen if they were to report their perpetrators. I've set out in this page, so if we move on to the applications for indefinite leave to remain, for reasons of domestic abuse, it should say, not domestic violence. The eligibility is that one has to be a spouse or partner of a British citizen, a person settled in the UK, somebody with refugee leave, or a member of the UK Armed Forces. And the relationship between the applicant and the perpetrator has to have broken, or their spouse has to have broken down as a result of domestic violence. This is really important because it's causation. And sometimes you'll find that some statements do not establish causation. So they'll say, for example, that this person suffered violence at the hands of their spouse, they were abused, they were controlled, and then perhaps the person left the family home, and within maybe after 2-3 months, something else happened that didn't constitute domestic abuse, and that as a result of that, so maybe the wife's parents said that he had to divorce or or separate from the wife, and therefore they say, well, then the relationship broke down. And if the statement says that, then clearly you haven't established causation. So causation is very important because the relationship, the rules are clear that the relationship has to have broken down as a result of domestic abuse. And one thing that is important to also remember is that there's no requirement for a person to have valid leave to remain in the United Kingdom at the time of the application. So you can make, the applicant can make an application even if they don't have any leave at that point in time. And that is because of a recognition that it takes a significant period for victims to leave their perpetrators. It also takes it also causes them some difficulty because quite often they do not have sufficient support, they do not have the documentation they require, and therefore this is a very important element of the application to remember, that in fact they don't have to worry about not having valid leave to remain in the United Kingdom at the time of making their application. It's also important to remember that that the eligibility, so although you have to have your last type of leave would have had to be on the basis of the partner rule, under the partner rules. Sometimes it is possible to have some form of discretionary leave, but that is more difficult to establish. And it also says eligibility is preserved for those cases where the grant of leave as a partner was followed by a grant under the destitution domestic violence scheme. And I will talk to you a little bit more about that. Before I move on, I'll just check if I have missed out on anything. Another matter to remember is that the applicant does not need to demonstrate knowledge of language and life in the UK under the domestic abuse rules. So, and that is an important matter to also consider. However, the problem is that there are limitations. The limitations are such that, for example, somebody who came here on a different form of leave, maybe came here as a student and then had a partner or got involved with somebody, they would not qualify under these rules, unfortunately, even if they suffered domestic abuse. On the other hand, domestic abuse under these rules also capture those who are not spouses. So you don't have, it doesn't have, the domestic abuse does not have to stem from a spouse or partner. It is enough if it's, for example, the in-laws that are the perpetrators. And sometimes you'll have cases where the in-laws are the ones who have been quite difficult, abusive, controlling, have made the relevant, the proposed applicant to undertake housework, have denied them the opportunity to study, have denied them the opportunity to go anywhere. And therefore they can still apply under these rules. So the abuse does not have to stem from the spouse. It's sufficient that it's from somebody within domestic arrangements. So for example, other family members and relatives, and that it's done without him protecting or at least turning a blind eye to it. The rules themselves, in terms of evidence, do not specify the type of evidence that must be provided. And of course, the standard of proof is that it has to be on the balance of probabilities to determine whether the breakdown of the relationship was because of domestic abuse. And again, that underlines the need for establishing causation. And if causation has not been established, then clearly a person will not qualify. The guidance that I referred to earlier and I set out in at page 3 also sets out a table of evidence, and that table of evidence is particularly helpful. It's from page 22 to 28, and the table of evidence sets out the different types of evidence. It's not an exhaustive list, but it also gives you an indication of the weight that the Home Office is likely to attach to different types of evidence. And you can go through the list with your clients to see what they may or may not have, or what they may or may not be able to get as further evidence in support of their applications. In terms of that list, or at least that table, what it does is that it shows which types of evidence are considered to be conclusive by the Home Office, others that are considered to be moderate, some are considered to be weak, and we'll discuss a couple of examples. But if you see the case at the bottom there of Suleiman, the court here discussed the need for the Secretary of State to consider to be fair in the determination of domestic abuse. And in that case, it was and the claimant's wife had been abusive, and he had made an application, but the Secretary of State had suggested that some parts of the evidence, so for example, she didn't consider the evidence of witnesses who had observed some of the abuse. She did not consider the reasons that led the applicant to remain within the relationship, or the claimant in that case, to remain in the relationship, did not consider the cultural pull that kind of forced him in the relationship, as well as perhaps his feelings for his wife. And the court stated quite clearly and firmly that it's really important to look at all of the evidence in the round, and that in ascertaining this evidence, that the Secretary of State is required to consider the demands of fairness. I move on to some of the examples of evidence that can be used, and I've kind of taken a few from the table within the Home Office guidance. And the first there is court conviction of an offence for an offence that fits within the definition of domestic abuse. That clearly is conclusive evidence that the domestic abuse occurred. But remember again that you have to establish causation. So it has to have led to the breakdown of the relationship. It's not enough to say that there was a court conviction maybe in 1988, and then in 2022, the victim now makes an application under ILR. I mean, it wouldn't happen that way, but as an example, that it's important to establish causation, and that the relationship broke down as a result of that. It could be that there was a conviction, and the spouse or the applicant continued to remain in the relationship. Of course, that is possible, and that's fine, as long as the applicant can say when the relationship broke down, and if it broke down as a result of the domestic abuse. It could be that it was a continuing course of conduct that culminated in a court conviction, or that started with a court conviction, and then the applicant returned to the relationship, and several things happened before the applicant then deciding that enough was enough and leaving the relationship. Police caution is also important, but one has to look carefully to consider what the caution was about. And reports to the police are also important, but again, you have to consider exactly what was said to the police. And sometimes you will see, unfortunately, where the police have a police report has been made, and the victim is asked a series of questions. For example, do you fear this person, the perpetrator? Do you fear them? And they say no. And remember, this is in the course of making a report of domestic abuse. And they're asked, has this person harmed you? So they answer these questions sometimes quite automatically because they're used to not disclosing domestic abuse. And then they end up disclosing just one incident, whereas perhaps their witness statement contains several other incidents or a course of behavior. So it's important to look at the reports very carefully and take instructions before assuming that the reports will corroborate the account fully. Non-molestation orders, occupation orders, and other orders for protection, such as restraining orders, are also clearly highly relevant. However, there's one thing to consider, that sometimes in non-molestation cases, the family court will make a without notice order, an ex parte order. So the respondent will not be aware of the application, and perhaps the non-molestation order will be made without notice to them. And then the family court normally lists a return hearing where the respondent can attend, and the respondent can say whether or not they dispute or accept the making of the non-molestation order. If they don't return, then the non-molestation order stands. The problem with that is sometimes where an application is made on the basis of a without notice order, because the Home Office are known to say, well, actually, that doesn't mean that the court accepted the allegations made. That doesn't mean that the respondent accepted that they carried out these incidents, and therefore it is not conclusive evidence of anything because it was without notice. So it's important to look at the order. The same with the occupation order, and the very fact that a person has an occupation order doesn't necessarily mean that that occupation order was granted on the basis of domestic abuse. It doesn't follow. Sometimes an occupation order will be granted for financial reasons or for other reasons. So it's important to look at the terms of the order and what the order says. You will also have to look at undertakings given by the perpetrator in the family court. That is relevant. And again, is important evidence. However, you have to look at the terms, and you have to also look at, sometimes what you get is you have the perpetrator giving undertakings, but cross undertakings given by the applicant too. And you'll reach that in the family court sometimes on the basis of negotiations between both parties. And therefore, it is important to look at carefully what the undertakings were given for and why. And sometimes there'll be in the recital some explanation as to what was said by both parties in terms of the undertakings and their reasons for giving them. But it is important to look at undertakings, and they could be highly relevant and corroborative. I would also say something very quickly about using family court orders. You will require permission from the family courts to disclose those orders, particularly if there are children involved. And therefore you have to look very carefully at getting permission to disclose those orders before you use them and put them in any immigration appeal bundle. Medical reports or letter from the GP, health visitor, midwife, community nurse, all highly relevant. I think, as you've seen in many of the cases that we use medical reports in, sometimes the Home Office argue, well, this person, the doctor or the professional or clinician has simply written what was relayed to them by the applicant. It doesn't necessarily mean that it's true. It doesn't necessarily mean that it has been verified or that the information is reliable. This is what she said. So if it is at all possible, if you have, for example, a letter from the health visitor or a midwife who has commented upon the applicant's demeanor or perhaps domestic abuse disclosed by the applicant, it is sometimes very good to write to them and seek out further information on how they perceived the applicant, what other indicators, if any, there might have been that this was a victim of domestic abuse. Sometimes you will find that a midwife has written that she signposted the applicant, or he or she signposted the applicant to a refuge or to a charity, and therefore you can write to them. I think it would be quite useful to write to them and ask why they did so, because that could actually help quite significantly and elevate this evidence to something that constitutes very strong evidence. Medical reports and letters from GP are also important. But to share with you a case that I had recently in the family courts, I had a case where we were going for fact-finding. And in the conference with the client, I asked her about, these patterns of behavior, her daily life, what was happening, just to see that that things, we didn't just have isolated incidents, and determine whether or not there was a pattern to the abuse. And one thing she said was, and that was in my instructions, was that there was no letter from the GP, and that she did not have any medical records from her GP. And I asked her why she didn't have any medical records, or why she couldn't obtain a letter from her GP. And I must confess, I assumed at that point that she just didn't think she just thought that she hadn't disclosed anything to the GP, and therefore it was irrelevant. But what she did say was that in fact she hadn't seen a GP or doctor for several years. And the reason why she hadn't seen a GP or doctor or any other form of doctor, and she hadn't sought any medical assistance, was because her partner had denied her the opportunity to attend or seek out medical support or advice. And this was clearly highly relevant. And in her evidence, when she told the judge, that was clearly something that was crucial. When we did obtain very, very brief medical reports, I think it was just maybe 2 pages long, it was clear that the first time she registered, it was through her partner. It was her partner who assisted her in registering, and then she hadn't been back since. So throughout, she had been home, not allowed to seek any medical assistance, treated herself for simple colds and other illnesses. At one point, her partner was bringing her medication that she assumed would make her feel better because she had an infection. But of course, this was not diagnosed. And so clearly, it's important to discuss the contents or lack of letters from GPs and medical reports with your clients. If it's somebody who has children, it's important to look at perhaps what you can get from the children's school. Quite often schools are good at observing behavior, observing signs of domestic abuse. Sometimes they don't get involved. And they don't, because they don't have the evidence, or they don't have sufficient evidence to raise the issues. But it's good sometimes to get a letter from the school, if you can see from the evidence or the narrative that has been provided that it is required. A letter from the social services is also important and is considered to be significant by the Home Office, particularly where the social services have become involved as a result of domestic abuse. I mean, that would be conclusive evidence that this happened. Domestic abuse support organizations and other organizations are also relevant. And the reason that it's important to contact them is that they can sometimes, because they work in these arenas and they work with victims of domestic abuse quite regularly, they will be able to give a lot of guidance to the applicants, a lot of support to the applicants, but also help you in terms of identifying the key issues that they have observed. I know that the Home Office often says, well, this letter is based entirely upon the applicant's account or narrative given to the domestic abuse organization. However, if the organization is able to say why they consider and what signs they have seen, then I think that it can become strong evidence. The list, as I said earlier, is non-exhaustive. It's not exhaustive, and it's important that that even if you don't have anything else, that you remember that the statement from the applicant is just as important, because that sometimes can provide a great deal of information regarding the domestic abuse, and it can give a great deal of detail in terms of the patterns of behavior that had led to domestic abuse and to its continuation. It's also important to remember, as the case of Suleiman, that witnesses are also important. So do not discount any witness evidence. So for example, a client comes to you and says, well, I was in X shop the other day and my partner came to me and hit me. If it is at all possible, perhaps get a letter from that shopkeeper, from that shop, make contact with them if it is possible, and they have video footage of that. Think about different forms of evidence that you can bring together and pull together, because I think it's quite normal to just think of the immediate things such as police reports or perhaps GP medical records, and then forget that in fact within a narrative there can be so many different clues as to steps in obtaining further steps to take in obtaining evidence of domestic abuse. So let's say that the applicant has suffered domestic abuse and the relationship has broken down as a result of that domestic abuse. They don't have anywhere to go. They don't have any support, and they will be destitute if they do not get any help. The domestic violence concession steps in and helps those applicants, and it gives access to public funds in order to help the proposed applicant to leave the relationship. It gives them time to gather any evidence they require, and they're then granted, if successful, 3 months leave to remain in the UK with access to public funds. However, the problem with this is that it doesn't necessarily mean that just because one has been granted leave under the domestic violence concession that they will automatically be granted ILR on the basis of domestic abuse. Unfortunately, the Home Office quite often distinguishes the two and doesn't use and specifically states that the Home Office is not, or the Secretary of State is not bound by the concession to accept the application for ILR. So it's very important to remind applicants of that. I will also make the point that where the applicant does not have any, for example, passport or any evidence, it's very important that they still submit their applications and that they provide and they state why they don't have the evidence. For example, if it's beyond their control because the passport is held by the perpetrator, then that's important. Sometimes you have to advise them to apply for a passport from their embassy and provide evidence of this, provide evidence that the application to the embassy has been submitted. And the problem with the concession is that it excludes a lot of different types of applicants or potential applicants. So it again, similar to the normal to the ILR application, it excludes anyone who has had any other leave form of leave prior to applying for the concession. It has to be as a partner. They would have had to been here as partners. So in some circumstances, it could be that somebody is arrived in the UK as a dependent on a partner who is, for example, on a tier 2 or a tier 4 visa. They would not qualify if they suffered domestic abuse because they were not here on that basis. They were not here on the basis of the spouse visa. However, they could apply potentially, and in many cases, for asylum or humanitarian protection. So for example, where the person says that they can't go back to their country because they will be blamed for the breakdown of the relationship, they will be blamed for the reports that they have made, and perhaps for embarrassing the family of the perpetrator. And therefore, it becomes the case that if they're not successful, that they might, or they wouldn't be successful, but it becomes the case that they might choose to apply then for under asylum, for asylum or humanitarian protection. In terms of funding, it's possible for the person to apply for a fee waiver and provide evidence of destitution, or at least provide evidence that they would be rendered destitute if they were to pay the fee. And this is important to remember, because sometimes what happens is a person does not have the funds available, but they are accommodated somewhere, perhaps in a refuge or at a friend's home. It is important then to get the evidence, to provide the evidence that perhaps they are being supported fully, accommodated and maintained by their friend, that they do not have the funds available to make the application, and that they need support and help in urgently, and therefore cannot make and therefore need a fee waiver. And this quite often can be successful, but remember to get a letter from the refuge. Remember to get the letter or clear documentation from any family or other support networks that they might have to verify the fact that they do not have any funds available to them and that they would be destitute. I mean, an example I've seen is a case where somebody was working, but they were earning so little that it was impossible, practically impossible for them to pay for their fees, and therefore they put in the application for a fee waiver and they got it. So it is possible to get it, but it's just a case of providing evidence and not forgetting to do so. Legal aid is of course available for victims of domestic abuse in immigration cases, so they need to be advised of this. I now turn to the issue of refusals, and before I do that, I will just outline some of the key challenges in making these applications, and then again in challenging any refusals. And one of the challenges, of course, as I mentioned earlier, is causation, that people forget to prove causation. Secondly, it's the nature of the domestic abuse, that it's important to have a very tight witness statement that sets out the course of conduct and that sets out the behavior that is alleged to be abusive. And third, it is to provide the relevant evidence of such, so to look quite widely. Fourth is that sometimes witness statements are not drafted in a way that that one can appreciate that this is a case of domestic abuse. So sometimes you will see that some of the cases, the application or the witness statement are drafted to say, well, this person was here, was brought here by their spouse, and now the relationship has broken down, but they have lived in this country for X number of years, they've developed this life, they've done all of this, and they assume that automatically that, and I understand that, because that can be phrased as a human rights application, but it doesn't necessarily mean that if you're applying for ILR under the rules on domestic violence, that you will get the Secretary of State determining it as both an application under the DVIR and an application under human rights, so Article 8. So what this application would give is, when you challenge it, so if you make an application and it's refused, then you will not get a right of appeal, but rather you will get a right for admin review. And we all know the difficulty in making admin review applications requests. So the domestic violence provisions of Appendix FM do state that the admin review would be what is the correct means of challenging. However, and this was confirmed in the case of MY Pakistan and the Secretary of State for the Home Department, and I've set out the case there. And one of the issues that the court was dealing with was somebody who had raised human rights issues in the domestic violence application to the Home Office. And the Home Office said, well, actually, we refuse the application on the basis of domestic abuse, and we will not engage with the human rights claim because you haven't used the correct form for human rights claim. And if you haven't used the specified form, then we are not going to engage with your submissions. So if you have anything else to say, then you have to make the right application. Otherwise, that is your leave refused, and therefore you have no other remedy. And the applicant applied to the court, and the court confirmed that in fact this was the case, that the Secretary of State does not have to engage with a human rights claim made under the domestic violence application. It doesn't have to engage with it, and in fact, if an applicant wishes to raise a human rights application, then they have to raise a specific application for that. The problem with that, of course, is that by the point that the ILR on the basis of domestic violence has been dealt with, of course, they become overstairs. And therefore, when they make the new application for under the human rights claim, then they're overstairs, and they do so as overstairs, and that is a difficulty. And the court considered that, recognized that, and pointed to the fact that, in fact, yes, this is an issue with one application at a time, that the Home Office wants to consider one application at a time. And indeed, if you look at paragraph 34BB of the rules, which is headed multiple application, it states that the applicant can have one outstanding application at a time if they have submitted an application in circumstances where the Home Office was already considering another application, then and that application wasn't determined or hadn't been determined, then it would be their first application would be treated as varied. So it would be treated as a variation of the previous application. If they submit several applications at the same time, or then the applications will be considered to be invalid. And then the Secretary of State then has discretion. So the wording in the rule is that the Secretary of State may give the applicant a single opportunity to withdraw all but one of the applications. So that is the case where an applicant makes maybe 3 or 4 applications, or maybe 2 different applications indeed, and they're asked to withdraw one of them, perhaps because it's not possible to vary, or perhaps they've made more than 2 and the Secretary of State decides to exercise discretion and give them an opportunity to withdraw 2 of those applications within 10 working days. And at that point, if they do not withdraw within those 10 days, then the applications are all considered to be invalid and will not be considered. And the court recognized the rule is harsh, but at this stage it is lawful. And therefore, one has to think very carefully about these applications when making these applications, that unfortunately that a person has that one chance potentially to make a really good application, to put in as much evidence as possible, and then to see what the Secretary of State's position is. It is possible to challenge by judicial review, but a refusal of domestic ILR on the basis of domestic abuse, but it's not possible to get a right of appeal. And that is important to remember. It's also important to remember that even if you're making the application, and even if the Home Office is not going to consider or engage with the human rights issues, that it's important to note them down, because clearly all of this will be part and parcel of the same situation, so to speak. And you never know what the outcome of the judicial review will be, in terms of perhaps the Secretary of State failing to recognize, as an example, family dynamics within which these incidents happened. So it's important to look at to provide as much information as possible, but also remember that unfortunately the Home Office will not engage with human rights claim that is embedded within the domestic violence application. They will consider the domestic violence application on its own. I will just see if there's any other point that I can see that I have 2 more minutes. Any other point that I have? Yes, I will say, I think that is it from me this afternoon. Thank you very much for listening, and thank you for your patience. I recognize that I was meant to speak earlier this morning, and I'm grateful to Sarah for filling in for me this morning. If you have any questions, I can see a couple of questions in the chat. I will go through them and I will try to respond later on. Thank you.
Well, Jamila, thank you very much. That was a very good and, may I say, very well presented talk. And I even got a tip from Wasanta to let you know that there were questions waiting for you in the Q&A box, but you spotted them. So thank you again very much indeed for attending in the course of a busy day for you.
Thank you, Richard.
Cheers.
I'm very happy to attend.
All the best. Bye-bye. Now we have one final talk, and that is from Joseph Byrne, who's going to take a closer look at statelessness in the new Nationality and Immigration Bill. Now, Joseph has got a bit of extra time himself. We've been running about 10 minutes over time. So Joseph, instead of finishing at 4:30, you're very welcome to finish at 20 to 5 if you need those extra 10 minutes. And let me just check that Joseph's here. I see his name's coming up. There he is.
Oh, yeah. Can you? I can't see myself. Can everyone see me?
Oh, I can see you all right, Joseph.
Oh, excellent. I'll share my screen as well. Thank you very much, Richard.
That's great. Well, look, I shall exit myself and leave the screen to you, Joseph, and look forward to hearing your talk. Thank you.
Fantastic. Thank you. I'm just getting this up. So hopefully now everyone can see my screen. Please do say if you can't. So yes, I'm going to be speaking about the nationality provisions in the Nationality and Borders Bill, which is currently making its way through the House of Lords, and I'll also be speaking about the registration of stateless children and some of the key case law and other matters relating to that. As Richard said, I'm conscious that we are running over a little bit, and this is the last talk of what's been probably a long day, so I will take things relatively quickly if I can do. If anyone's had a chance to look through my PowerPoint, it is quite detailed, so you shouldn't need to take any notes or anything. It should all be in there. And again, for that reason, I might take some of the slides relatively quickly because you've already got all the information down there. So first of all, as I said, that the nationality provisions of the Nationality and Borders Bill, this is just one part of the bill. There's a whole other section about asylum matters, which has also been quite controversial, which you'll no doubt have some awareness of. I won't be talking about that today because there simply isn't enough time. So I'll be focusing on this part one on nationality and citizenship. And just to give you a bit of background and a bit of a timeline about where we are with the bill, this is the current stage that it's at. It's made its way through the House of Commons. It's now in the House of Lords. It's had its first 2 readings and its committee stage. That's actually now complete. So it's got the report stage and a 3rd reading left before it goes back to the Commons. So of course this isn't law yet, this is just a bill. The clauses are still open to amendments by the Lords and indeed the House of Commons if necessary. So by no means take this as settled law as yet, but it looks like this is the shape it's going to take. Of course, with the majority of the government it doesn't need to accept any amendments. It can plod on as it likes to some degree. So first of all, the first 4 clauses of the bill deal with British Overseas Territories citizenship, which I'm going to call BOTC because it's quite a mouthful. And the first clause in the bill is dealing with the historic inability of mothers, BOTC mothers, to transmit citizenship to their children where the child is born outside of a British overseas territory. And this clause remedies that by giving a registration route for the children of such mothers. The equivalent, as you can see there, the equivalent issue was already remedied in relation to citizenships, British citizenship, to allow mothers there to pass it on, but there was this gap remaining in relation to BOTC, and this seeks to remedy that. So that's relatively straightforward. Likewise, the second clause does exactly the same, but in relation to the children of unmarried fathers who are BOTC citizens. So where your father was a citizen of a British overseas territory, but not married to your mother, previously the citizenship didn't pass, and this again remedies that by creating a registration route for those children. Clause 3 again is another measure which seeks to correct those same historical discriminations, and what this does is it creates a route to British citizenship, so not BOTC but British citizenship, for those who already register as BOTCs under the first 2 clauses. Once they've done so, they'll then be able to actually register as British citizens as well. A couple of drawbacks with this clause. One, it's a shame that there's no way to jump directly to British citizenship. You still have to go through the hoops of registering first as a BOTC and then as a British citizen, which slows down the process a little bit. And secondly, as you can see at the bottom there, this is subject to a good character test. So in order to register under this clause, applicants would have to show they are of good character. And now this has been the subject of some criticism by a number of bodies, notably the Project for the Registration of Children as British Citizens, the PRCBC, and also the Joint Committee of Human Rights. You can see the Joint Committee on Human Rights summarise the criticism quite succinctly there. They say, we consider that is unlawful discrimination, contrary to Article 14, as read with Article 8 of the ECHR, to require a person to prove good character when remedying previous unlawful discrimination against that person. And they recommend that this clause, this part of the clause, that the good character requirement be removed. And that seems to me to be a very powerful objection. That why is it that if the UK is remedying discrimination, why are we putting a gateway and only removing that discrimination to those that the Secretary of State deems to be of good character? Even if someone isn't of good character, they're still entitled not to be discriminated against. So it's quite a powerful criticism, that, but we are where we are. That is currently how the clause is drafted in the bill, and so it remains to be seen whether there will be any successful move to remove that. Clause 4, again, this is the last clause that relates to BOTC, and this amends section 17 of the British Nationality Act, which currently requires provides a registration route for BOTC for children who have a parent that is a BOTC by descent and who has lived in a BOTC for 3 years continuously before the child's birth. Currently, applications can be brought, but they have to be brought within 12 months of the child's birth, which is different to the position for British citizenship, which allows it to be brought any time when the applicant is a child, and that's precisely what this clause would do. It would bring the position for BOTC in line with the position for British citizenship. So these first 4 clauses are largely sweeping up discriminatory issues that have already been remedied for British citizens, but not for BOTC. And just as a reminder, those I thought it'll be helpful to include there the list of the 14 British overseas territories, just so we know who we're talking about. So moving on to clauses 5 and 6, which are focusing on British citizenship. The first is clause 5, the disapplication of historical registration requirements. Again, this amends the British Nationality Act 1991. So the applications for registration under section 4C, which relates to British mothers, and section 4I, which relates to unmarried father, will no longer be refused solely because of historical requirements to have registered the applicant's birth within a year. Previously, if you didn't, or currently, sorry, if you haven't, if the applicant's birth wasn't registered within a year, applications for registration would fall for refusal, and this reverses that, and it's a reflection of the Supreme Court's decision in that case. You can see there. I should say now that all of the cases in the PowerPoint and some of the other briefings and things referred to are all hyperlinked, so you can go and have a look at these in more detail if you'd like to. Clause 6, this is about citizenship where the applicant's mother is married to someone other than the natural father. This again amends the 1981 Act to provide an entitlement to British citizenship for individuals who are previously unable to acquire it because their mother was married to someone other than their biological British citizen father at the time of birth. And again, this remedies. This was a previous attempt to remedy this, but there was a bit of a gap, which is explained there. So this is filling that gap. And again, this reflects a recent or relatively recent decision of the High Court of K, which you can see there. Clauses 7 to 9, these relate to powers of the Secretary of State relating to citizenship. Clause 7 gives the Secretary of State the discretion, and it is only discretionary, to register British citizens or BOT citizens as appropriate, if she considers that they would have become citizens but for historical legislative unfairness, an act or omission of a public authority, or exceptional circumstances relating to the applicant. So in relation to that first requirement, historical legislative unfairness, this includes circumstances, and this is from the wording of the clause, this includes circumstances where the applicant would have become or would not have ceased to be a British subject, a citizen of the UK and colonies, as was, or a British citizen, if legislation at the time had, for the purpose of determining a person's nationality status, treated males and females equally, treated children of unmarried couples in the same way as children of married couples, or treated children of couples where the mother was married to someone other than the natural father in the same way as children of couples where the mother was married to the natural father. Again, that's a bit of a mouthful, but you can see really that this is effectively a sweep up of the same issues we've seen in the previous clauses, that gives the Secretary of State a discretion where these issues haven't been swept up. If there are any further gaps, unforeseen gaps, in remedying these issues, and also, as we saw on the previous slide, in exceptional circumstances. So that's a new discretionary route to citizenship, or indeed British Overseas Territory citizenship. Clause 8, do it relatively quickly. This is about the requirements for naturalisation. Currently, in relation to the requirements for naturalisation, there's of course a requirement, a residential period that the applicant must have lived in the UK for a certain amount of time. Currently, the Secretary of State has a discretion to waive the fact that the applicant has had more than the permitted number of absences, but the Secretary of State doesn't currently have the power to waive that in relation to the start of the qualifying period, and this gives the Secretary of State such a power. So it broadens that power, and hopefully avoids difficult situations where someone wasn't in the UK at the beginning of that period. So come now to clause 9, and this is one of the most controversial aspects of the bill, which you may have heard of. Clause 9 relates to the Secretary of State's power under section 40 of the BNA, the British Nationality Act 1981, for the Secretary of State to deprive a person of citizenship. And she can do that in one of two circumstances under the current law, either where deprivation is conducive to the public good, that's in subsection 2 of section 40, or in the case of a registered or naturalised citizen, where that citizenship was obtained by means of fraud, false representation, or concealment of a material fact. Now, that's the law as it currently stands, and that's not going to change. What is going to be amended, or is going to be have a qualification to it, is subsection 5. Now, subsection 5 of section 40 requires the Secretary of State, before making a deprivation order, to notify the person in writing, give reasons for the deprivation, and inform them of their right of appeal. And that's really what this clause 9 is aimed at, as we'll see. Clause 9, what it does is it dispenses with that notice requirement in subsection 5, where it appears to the Secretary of State that A, the Secretary of State does not have the information needed to be able to give notice under that subsection, or B, where it would for any other reason not be reasonably practicable, to give notice under that subsection, or C, where notice under that subsection should not be given either in the interests of national security, in the interests of the relationship between the UK and another country, or otherwise in the public interest. So that we can see that it's a very broad power for the Secretary of State to dispense with the notice requirement. Effectively, there's a number of specific examples, but the last part of part C, where it's otherwise in the public interest, that's very broad indeed. And not only that, but clause 9 is designed to act retrospectively. The clause says that a failure to comply with a duty under subsection 5 of section 40, so that's the notice requirement, in respect of a pre-commencement deprivation order, so that's a deprivation order made before this clause comes into force, if and when it does. So that a failure to do so does not affect, and is not to be treated as never having affected the validity of that order. So it has a very clear retrospective effect if this becomes law to deal with any difficulties the Secretary of State might face with any existing deprivation orders that were made without notice. Now, this is really a response by the government to was originally a decision of the High Court, and as of the last month or so, the Court of Appeal in a case called D4, which you can see there, and that case was considering the government's previous attempt to do away with this notice requirement, which was Regulation 10.4 of the regulations, the British Nationality Regulations 2003, and both the High Court and the Court of Appeal found that unlawful. Regulation 10.4 deemed notice of a deprivation decision to have been given in certain circumstances, even where it had been simply placed on a person's Home Office file. So effectively no notice at all. And that was found to be unlawful by the court, and effectively this clause seeks to put that on a statutory footing to reinstate it, albeit in slightly different terms. Apologies. So the effect of clause 9 really is that those subject to a deprivation order without notice do still have a right of appeal, but crucially, they no longer have any right of appeal until the order has been made, because there is no prior notification. So this has been called a deprive first, appeal later system. And secondly, and again importantly, that the person in question may not be, and indeed may never become, aware that their citizenship has been removed, or even that the need for appeal arises, precisely because there's no requirement on the Secretary of State, if those conditions are met, to notify them at all. As I said before, this has been certainly a very controversial proposal, and it's been the subject of a huge amount of criticism. There's a few items here extracted from the joint opinion of Raza Hussain QC, written along with Eleanor Mitchell and Jason Popjoy. If anyone has an interest in this clause and the proposals, I would certainly encourage you to read opinion. It's very long and detailed, but it's actually very accessible. It's very clearly written, and sets out the position very powerfully. A few things I've highlighted here. Firstly, that they say that they conclude that the use of the powers conferred by clause 9 would be highly likely to give rise to deprivation decisions that are incompatible with Article 6 and 8 of ECHR, and potentially Article 14. So effectively Article 6, because it does away with, it frustrates the access to an appeal, because if you're not even informed of an appeal, you're not given reasons, your ability to access that appeal becomes very difficult. Article 8, because of your citizenship is being deprived arbitrarily in a sort of the formal legal sense, again without notice and without reasons, which of course affects your private life. Article 14, which is of course about discrimination, because the effect of the order is going to be felt most keenly by those who have nationalities, who have dual nationality, or are able to acquire another nationality. It affects those citizens much more keenly. So that's a very clear conclusion that they draw. And again, if you want to look at all the reasoning in more detail, you can see their opinion, which is freely published online. Secondly, they say it is a fundamental principle of the UK legal system that notice of a decision is required before it can have the character of a determination with legal effect. And they provide the authority for that in Anu Fajeva. And linked to that notice requirement, that's a fundamental principle, has also been consistently given effect by the UK courts, precisely in the context of decisions relating to citizenship. And that's the case of Alpha I referred to. So a very clear view expressed there in that joint opinion. Go to the next slide. It's not just that opinion, though, that there's plenty of other bodies queuing up to criticise this, that the UNHCR guidelines on statelessness are often referred to in that context. The guidelines say, as you can see there, that state decisions involving the acquisition, retention, or renunciation of nationality should be issued in writing and open to effective administrative and judicial review. The individual whose nationality is withdrawn should also be provided with written reasons for the withdrawal in a language they understand. And clearly that won't be the case for deprivation orders made under this clause. So clause 9 is therefore criticised as being contrary to the common law rights under the ECHR and also international standards. There's a number of further sort of more policy criticisms are made, again in a very helpful briefing by the PRCBC, which is linked there. I won't go through all of these in detail, but that second one there is worth noting, that they make the point that not informing someone that they are no longer a citizen may have very dangerous consequences, that the person may unwittingly put themselves in danger because they believe they continue to have an option to leave a foreign country on a British passport, or indeed may continue to seek consular or other assistance from the UK government, effectively not knowing that is no longer open to them and will no longer be provided to them. They also note that it's particularly dangerous where the subject of the order is abroad, as it can lead to their appeal rights being made permanently inaccessible, even if the decision is ever communicated to them. And they note the difficulties obtaining the full disclosure from the Home Office, the likely difficulties in instructing a lawyer with a relevant experience from abroad and communicating with that lawyer, and indeed engaging effectively with any appeal that they do have. And that was obviously highlighted in the Begum case in the Supreme Court last year. In that case, it was found that Shamima Begum couldn't effectively engage in her appeal from abroad, and she couldn't come back to the UK because of security concerns. And so her appeal was effectively being stayed indefinitely until such time as that changes. So it's very clear to see how those subject to these orders made without notice could and likely will have a very difficult time actually engaging with and accessing an appeal. There's another criticism there made by the PRCBC on the basis that the fact that one of the conditions in which the Secretary of State can dispense with the notice requirement is where it is, quote, in the interests of the relationship between the UK and another country. Now, they said that's particularly concerning, as it may be in the interest of that relationship precisely because that other country wishes to do the British citizen harm. So a huge amount of criticism for clause 9, but again, it is part of the bill. It's not been amended as yet in the Lords. There have been amendments proposed to water it down or remove it entirely, but those remain yet to be sort of resolved. So we'll have to wait and see. The final clause in the bill, which in the nationality section relates to stateless minors. I will come back to this because before we look at that clause, we're going to look now at the current position with respect to the registration of stateless minors. So you may be familiar with this, but as a recap, the registration route for stateless minors is found in paragraph 3 of Schedule 2 of the British Nationality Act, and I've set it out there. A person born in the UK or BOT is entitled to registration as a British citizen or BOTC as applicable, where the following requirements are satisfied. The first and crucial one is that he or she is and always has been stateless. The second is that on the date of application, he or she was under the age of 22, and thirdly is the requirement that they have been in the UK or the British Overseas Territory for 5 years with permissible absences. And again, there's a discretion for the Secretary of State to waive if the number of absences exceeds the permissible 450 in that period. So those are the requirements as they currently stand for registration as a stateless minor in the UK. You can tell from options from requirement C there that because you have to have been in the UK for 5 years, it's not open to children under 5. You have to wait until the child has hit 5 years. There's a few things that I'm going to go through very quickly. Firstly is a bit of background on the meaning and the definition of statelessness. And there's two key cases which actually are both deprivation cases, but the meaning of statelessness applies equally to registration cases. That's the cases of Al-Jeddah and Fam. Then we're going to look at what's really the key case on the registration of stateless children. That's the case of McKee. We're then going to look briefly at the recent judgment on fees, which applies to all registrations for applications for children in the UK. And lastly, then we'll return to the Nationality and Borders Bill and Clause 10 and look at the effect of that if passed. And as you can see there, spoiler, it's a bit of a reversal of the decision in McKee, but we'll come to that in due course. So first of all, the meaning of statelessness, and this is the case of Al-Jeddah in 2013. So Al-Jeddah was an Iraqi national by descent, but then acquired British citizenship, and in the course of doing so, thereby lost his Iraqi nationality. The Secretary of State made a deprivation order, and he challenged that under Section 44 of the BNA on the basis that the order would render him stateless. So the appeal proceeded, as it says there, on the factual basis that at the date of the order, Al-Jeddah had a right to the immediate restoration of his Iraqi nationality on application to the Iraqi authorities. the position, I think, was actually a bit more complicated, and the court was a little bit wary about making such a factual finding and proceeding on that basis, but they did so. So effectively, the Secretary of State's position was that in such circumstances, her deprivation order didn't make Al Jeddah stateless. What made him stateless, or what would make him stateless, would be his failure to complete what they said was the simple step of applying for restoration of his Iraqi nationality, which he could have simply done straight away and had his nationality restored. And it was held that whether a person could, with whatever degree of ease and speed, reacquire, or indeed acquire for the first time, another nationality was not relevant to the key question of statelessness. And that question simply was whether he would be made stateless at the time of the order. So simply because you can very easily acquire another nationality after the fact, that doesn't change the position that you have been made stateless. And the deprivation order was found to be unlawful on that basis, because it would indeed render Al Jeddah stateless. Now, before we move on from Al Jeddah, just as a slight aside, just moving away from the registration of stateless children, a bit wading into deprivation again, it's just important to note that since Al Jeddah was decided, the BNA and the law relating to deprivation has actually been amended, and section 44A of the BNA does now allow the Secretary of State to make a deprivation order which renders a person stateless in particular circumstances, effectively where, as you can see there, the citizenship results from naturalization; B, where their deprivation is conducive to the public good, and it's just a bit more of a gloss on that; and crucially, C, where the Secretary of State has reasonable grounds for believing that the person is able, under the law of a country or territory outside the UK, to become a national of such country or territory. So you can see that if that had applied at the time of Al Jeddah, the actual substantive decision in Al Jeddah would have been different, because although he still would have been made stateless at the time, he could have then acquired another nationality, and therefore the Secretary of State, her deprivation order would have been legal under this provision. But I'm noting that there just to note a change in the law, but that carve out doesn't currently apply to the registration of stateless children, and doesn't affect what we're looking at here, which is that the meaning of statelessness. And the principle in Al Jeddah is still the same, that just because you can acquire nationality later, whatever that means in the context of deprivation and in the new amended law, if you don't have any other nationality at that date, you are made stateless, and that's the key principle. The other case we're going to look at is case of Pham and the Secretary of State. That's a 2015 Supreme Court case. In many ways, this is the converse of Al Jeddah. In this case, Pham was a Vietnamese national, and he argued that, as well as a UK national, and again, this is a deprivation case where he was challenging the lawfulness of the Secretary of State's order to deprive him of his UK nationality. Now he argued that although he might have been Vietnamese, there are statements made by Vietnamese authorities after the date of his deprivation order, but of course before the appeal, which suggested that they might refuse to recognise his status as a national, or otherwise might withdraw his Vietnamese nationality. So you can see this is the opposite. This is not about being able to not having nationality and being able to easily acquire it after the order. This is about if you already have another nationality, and there's the risk that might be withdrawn after the order. Now, the Supreme Court held that these facts were irrelevant to the question of his statelessness at the point of the order. If Vietnam did withdraw his nationality or refused to recognise his nationality after his British nationality was removed, then it would have been Vietnam that had rendered him stateless, not the Secretary of State. So Pham lost his appeal. So just as a quick summary, where we're left with after Al Jeddah and Pham is that in determining whether a person is stateless, the question is simply, at the relevant time, do they have the nationality of another state? Whether or not they could very easily acquire another nationality after the fact, or whether or not they have a second nationality that might be removed after the fact, neither of those factors are relevant. Returning then to the registration of stateless children, the key case, as we said earlier, is the case of McKee, which is a 2017 case. Here, the facts were that the claimant had been born in the UK, the child of Indian nationals, had applied to register under the BNA Schedule 2 that we saw before. And the central question in the appeal was precisely that, whether or not MK was and always had been stateless in accordance with that paragraph. Now, it was found, again, as a matter of fact, before deciding the legal matter in the appeal, as a matter of fact, the judge found that under Indian law, the claimant MK had since birth been able to acquire Indian nationality by registering her birth, or by her parents registering her birth at an Indian consulate. And the Secretary of State's position was that this meant that MK was not stateless, as she has and had always been able in practice to very easily acquire Indian nationality. Now, the court disagreed with this and did find MK to be stateless. Unsurprisingly, in the context of what we just read, the court relied on Al-Jeddah and Pham and made abundantly clear that those principles apply not just to deprivation, but also to statelessness in the context of the registration of stateless children. So that's really the key case as the current law currently stands. There's also, in that same case, it's quite helpful for these applications because of a number of comments that the judge made about the need for flexibility from the Secretary of State in how she expects applicants to evidence their statelessness. So the judge said, the Secretary of State is not entitled to impose requirements that make it impossible for an individual to obtain a benefit that is his by statute. There will have to be flexibility to cover cases where it will be exceptionally difficult or impossible to obtain the documents sought. In such cases, the Secretary of State has to be willing to consider proof by some other means. Her unwillingness to do so, despite the evidence of difficulty, appears to me to be unreasonable. Now, this really arose out of the facts of MK's situation with her eligibility for Indian nationality. What the Secretary of State effectively wanted, one of the reasons for refusal is that they wanted MK to provide evidence, sort of conclusive evidence that she hadn't been registered as an Indian national. But the way that Indian nationality worked is there was no centralized body in India which MK or her parents could write to ask them to confirm whether or not she was a national. The only way they could do so would be by showing that, by writing to every single Indian consulate and getting every single individual Indian consulate to confirm that she hadn't been registered with that specific consulate. So it would have been logistically incredibly difficult to do so. And that's really the kind of thing that the judge had in mind. And the judge went on to say, although he did note that it's not necessarily for the courts to tell the Secretary of State what type of evidence that she should be accepting. But the court did go on to say that despite the suggestion that it would be self-serving, it appears to me, the judge said, that a clear, unambiguous sworn statement by each of the parents ought to be regarded as having some value. So again, for example, in that case, rather than expecting the parents to have written to every single consulate for confirmation, the judge is suggesting that a sworn statement by them to confirm that they hadn't registered their daughter's birth with any Indian consulate wouldn't necessarily be conclusive evidence, but would have some value and should be regarded as having some value by the Secretary of State. So that's some quite helpful comments from the court about the need for flexibility from the Secretary of State for proving what can be otherwise a very difficult thing to prove, effectively proving a negative that you don't have nationality. The decision in MK, as you can see here, is also reflected in the Secretary of State's guidance on statelessness leave. It has a sort of quasi-definition of stateless there, or circumstances in which someone will be stateless, and one of which you can see there is where they have not registered for a nationality to which they are entitled, having been born outside the country of their parents' nationality. So it explicitly acknowledges that even where someone might be entitled to a nationality but haven't registered for it, then that means they're stateless. So turning then from MK just to a recent judgment in the last month or so, the case of O. This is a disappointing case you might have heard about already. This is the case that considered the lawfulness of the fees of just over £1,000 for child registration applications, and whether or not that was unlawful because it effectively made it practically unaffordable for children to exercise those rights, and therefore rendered those rights nugatory. Sadly, that the court dismissed the appeal and upheld the lawfulness of the Secretary of State's fees. Those are really the two key paragraphs, which broadly say, firstly, that the Immigration Act 2014 explicitly authorises the Secretary of State to set the fees how she wishes, without any criterion of affordability, and it expressly empowers her to do so, to set the fees at levels which take account of the benefits likely to accrue from citizenship, and importantly, that could subsidise the cost of the exercise of other functions in connection with immigration and nationality, because that was really one of the key thrusts of the arguments, as well as the general unfairness argument, was that the fees, although they're over £1,000, I can't remember the numbers off the top of my head, but I think only £370 roughly of it is actually to cover the cost of the application. The rest of it is effectively to subsidise the rest of the Secretary of State's immigration activities. But sadly, that the court found that was entirely permissible under the powers of the Immigration Act. In that second paragraph there, you can also see what the court said with regards to the question of whether it was appropriate for the Secretary of State to impose such fees. And the court said that question is really a matter of policy for political determination, not a matter for judges. So declining to take too interventionist an approach into what they saw as a policy decision. So that is a disappointing decision that those fees have been upheld as lawful. So coming back now finally to clause 10 of the Nationality and Borders Bill, which deals with the registration of stateless children. So clause 10 would amend the paragraph in question of the BNA, which we saw earlier, in the following way. Firstly, it's important to note that the current requirements would be exactly the same, even under clause 10, for applicants aged 18 to 22. If you remember, it's applicants can apply anytime up to the age of 22 if they're stateless. And for adults, so 18 to 22, clause 10 changes nothing. But crucially, for applicants aged 5 to 17, so for minors, clause 10 introduces an additional requirement that the applicant be unable to acquire another nationality. And the amendment, also the clause, provides that the person is able to acquire nationality for those purposes where A, the nationality is the same as that of one of the person's parents, B, the person has been entitled to acquire the nationality since birth, and C, in all the circumstances, it is reasonable to expect the person or someone acting on their behalf to take the steps which would enable the person to acquire the nationality in question. So we can see that really this appears to be squarely directed at entirely reversing the position that was established in MK. And indeed, if this applied to the facts of MK, MK would fail, because would very likely fail, because it's very likely that she would it would be considered reasonable to expect her to take steps to have registered her birth with an Indian consulate. Although there may be some room for argument there, but it would be likely be an uphill battle. Now, the government justification for the need for clause 10 points to quote, and this is from the House of Commons debates. They point to an increasing trend of applications for children whose parents did not take the step of registering their child's birth with the embassy or High Commission, leaving their child without a nationality. As we'll see in a few slides' time, it's not entirely clear where that trend, how that trend was identified, and indeed whether or not it's consistent with the Home Office's own data. But we will come on to that. But the first thing to note is that there is some support for what the government's saying, or at least that there is a recognition of the potential of such an issue in the MK decision. Judge Oxton there said the following. He said, "I recognise, of course, that this conclusion that he came to an MK opens an obvious route to abuse. Indeed, the facts of the present case might be said to be an example of abuse. M&F, the mother and father, are both overstayers. Both have sought and been refused further leave. They have preferred to allow C, that's MK, to be stateless all her life to date, rather than to register her birth and obtain Indian nationality for her. Yet C's right to British nationality and the consequence that she will not be or become a national of India will now immeasurably improve M&F's prospects of being allowed to stay in the United Kingdom. So the judge did explicitly recognise that there's a possibility for abuse here, and indeed this paragraph is explicitly referred to by government ministers in justifying the need for clause 10. Again, needless to say that the clause has been, like clause 9, has been the subject of a very heavy criticism. Firstly, it's important to note that section 36 of the British Nationality Act, which is the section which gives effect to Schedule 2, expressly says that it does so for the purpose of reducing statelessness. Sorry, there should be a close quotes there, for the purpose of reducing statelessness. And indeed, ministers have noted that the provisions of that schedule are required to ensure compliance with our international obligations under the UN Convention on the Reduction of Statelessness. But critics have highlighted that far from being intended to prevent or reduce statelessness or childhood statelessness, the effect of clause 10 is precisely to increase instances of childhood statelessness. The European Network on Statelessness, again, this is a hyperlink to a very helpful briefing that they produced on this. They've pointed to research that there are already, under the current law, significant law, policy and practice gaps preventing many stateless children in the UK from realising their right to acquire British citizenship. And of course, this is only going to make that more difficult. The PRCBC presents data in their briefing, which again is hyperlinked there, on the annual number of registrations under Schedule 2, which they say show that after a spike in 2018, which they say is following their work to raise awareness about the registration route, and of course the judgment of McKee, which happened in 2017. After a spike in 2018, there's actually been a consistent fall in the number of registrations in subsequent years. I made a brief note of that. So in 2017, there were just over 100 applications under this route. In 2018, it increased to over 2,000, but then in 2017 down to 1,000, 2020 down to 890, and 2021 it was in the 600s. So there's a very clear downward trend there. So that seems somewhat at odds with the government's assertion that there's a growing trend of people abusing this, and it's sort of spiraling out of control. And actually, the data shows that the numbers are coming down. And the PRCBC make a very strong point, which is quoted there. They say that the Home Office has simply responded to a rise in children exercising the rights that Parliament has given to them by seeking to curtail the rights in question. They've done so with no appreciation of the injustice it has long done by effectively leaving many children born in this country stateless, by failing to take steps to raise awareness of the children's rights and remove barriers to registration of citizenship, including the fees that we've just talked about. It's also made no assessments of the best interests of children and the impact of their growing up excluded and alienated by their continued deprivation of any citizenship, and in particular, the citizenship of the country in which they were born, and in almost every case, will have lived every day of their lives. Similarly, the Joint Committee on Human Rights have also produced quite a lot of work on this and commented quite a lot on it and criticised clause 10. And in summary, they say it's difficult to see how the clause complies with the UK's obligations under both the 1961 UN Stateless Convention and the UN Convention on the Rights of the Child. And they recommend that it be amended, preferably deleted altogether. Just in the last week or so, towards the end of January and beginning of February, this has been debated in the House of Lords. And again, it's coming for a lot of criticism from opposition parties in the House of Lords, because it places the onus on the child to evidence that they couldn't have reasonably acquired another nationality, which could be very difficult to prove, because it creates an anomaly whereby stateless children who don't meet the requirements will not be able to register. But then, because it only applies to children, it doesn't apply to 18 to 22-year-olds. Once you reach 18, having been stateless effectively your entire life as a child, you are then entitled to register. It's unclear what the benefit would be to the UK in effectively enforcing the statelessness of a child until they reach adulthood and then begrudgingly giving it to them. If that option is going to be given to them at the age of 18, why not as a child? They've also, the government's justification for the clause has also been criticised as that it smacks of the culture of disbelief and suspicion criticised by Wendy Williams in the Windrush report. And And similarly, this is again an instance of the hostile environment and the lessons of the Windrush report, and others simply still haven't been learned, and the same culture exists. Lastly, a few other points made in the House of Lords. Firstly, that the clause 10 risks punishing the child for a perceived failure. And just on that, it's not entirely clear to me how it would operate. Because, for example, like with, I think this was the case with MK in relation to Indian nationality, in many cases that the way a child is able to acquire the nationality of their parents is has a deadline. So, for example, they have to have registered their birth within, say, the first 12 months. If they miss that 12-month deadline and are now aged, let's say, 7 and want to apply to register as a British child, but are unable to do so because of this new provision, they can't then go back and acquire Indian nationality. So they are then just left stateless. They have no options. That the option to acquire nationality may well have already gone. So then they have no option whatsoever of acquiring a nationality. So children and their parents could be very, very harshly punished for the failure to register within what might be a very short amount of time after birth, which of course might be, as the government say, be to abuse, maybe because a specific decision made by the parents in an attempt to gain British nationality, if that's abusive. But it may also just be because for any other reason, that there could be many reasons why parents are unable to make such acquire that nationality for their child because of difficulties. They might not even know it's an option. There are lots of reasons. So the risk of punishing a child for a failure in their first 12 months of their life, for example, is a real one. And again, it's highlighted that this could be very damaging to the child's development, and that the government has made no assessment of the impact it will have on those children. I put there just the response of in the House of Lords of the Conservative peer who was defending the clause 10. She maintained that it complied with international obligations and that it was necessary due to the stark increase in applications between 2010 and 2017, which she said was quite obvious evidence of the abuse referred to in MK. Again, it's not clear how that could be maintained in light of the evidence produced by the PRCBC, and indeed, during the debate, she was asked to provide sort of evidence for her claim about there being obvious evidence of the abuse of the kind referred to in MK, which I think remains outstanding. So they have, very briefly, I know we've already overrun. I will hope to finish in the next 2 or 3 minutes. There have been a number of proposed amendments to clause 10, removing it entirely or watering it down slightly, or having a best interest requirement. Again, none of these have been accepted yet by the Lords. There is still, we do still have further to go, as we can see in the process. There's still the report stage, which will be starting in the next week or so, which has further opportunity for amendments, and then the third reading, and then of course it has to go back to the House of Commons. So none of this is set in stone. It could be amended, and some of these clauses might be watered down or removed entirely. But we will just have to wait and see. So I think that's everything I wanted to go through. If there are any questions, just because of the time, it might be easier if you've got my email there. If anyone wants to drop me an email, and I can answer those over email, I'd be very happy to do so.
Oh, I was having a spot of bother unmuting and unstopping my video link. Well, Joseph, I hope you're still around. Thank you very much for that very useful and informative talk. And also, I don't know if you've had a quick look at the Q&A or chat box. I don't think there's anything outstanding at the moment.
Yeah, I had a quick look. I think those are all DV related questions.
Okay. Well, that's fine. As you say, people can email you if they've got any queries anyway. So again, thank you very much indeed for bringing up the end of a pretty long day for the participants, but giving a very informative and useful talk. So thank you very much, Joseph.
Thank
And
you very much.
thank all of you who've stuck it out this long. I see there are 60 participants. Don't say you're all still here. That's very good if you are. So I hope you found it useful and productive, and hope that more of you will be able to come back to another AstenJ webinar later in the year. So for now, all the best and goodbye.